Good afternoon. Due to COVID-19, Committee of Adjustment public hearings are being conducted virtually by electronic means through WebEx Webinar, an online digital platform, and streamed on the Toronto City Planning YouTube channel. Participants who have registered in advance will be able to make their presentations to the committee using WebEx, which is moderated by city staff. Anyone wishing to view the hearing may watch on YouTube. My name is Bruce Mullock. Panel members this afternoon are Yim Chan, Peter Reed, and Nimrod Salomon. Participants who have registered in advance will be connecting via their computer, tablet, smartphone, or telephone. All participants will automatically be muted on entry. When an item is called, each participant will be unmuted by the moderator, one person at a time. We ask that you also mute your devices until you are called on to speak. Today, Committee of Adjustment is offering attendees the option to appear by video. Those attendees that have registered in advance to attend by video will be temporarily upgraded to panelist status when the item is being heard. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Members of the public and the applicants are not allowed to use share screen or any other panelist controls during a video presentation. The moderator will remove you from the panelist role if you fail to respect this instruction. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. The Committee of Adjustment also acknowledges with deep sadness the death of Toronto Police Service Constable Andrew Hong. In accordance with Sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to property, permission to extend or to alter lawful non-conforming uses, and consent to sever property in order to create new lots. Anyone in attendance today who wants to receive a copy of the decision of the committee on an application must submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because the Committee of Adjustment and the Toronto Local Appeal Body, TLAB, will be sending notifications by email only. You may not agree with the decision of the committee. Decisions may be appealed to the Toronto Local Appeal Body, TLAB, or in some limited circumstances, to the Ontario Land Tribunal. Appeal instructions are set out at the bottom of the decision of the committee. I will call each item in the order that it is listed on the agenda. Where an application is uncontested, the agent or applicant may proceed with their presentation if so requested by the committee. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions or take the application into committee for a decision. Each speaker, including the applicant, agent, will be given a maximum of 5 minutes to address the committee. I will comment to you as you're approaching the mark. When addressing the committee, please clearly state your name and address. And please remember to confine your remarks to the matters outlined in the application. The applicant may be asked to make a presentation to the committee. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised in order to ensure the revised application is accurate and that all those entitled to notice are informed of the changes. Then individuals, either in support of or opposed to the application, will be invited to speak. Committee members may ask questions of speakers after they have finished their presentations. When all the speakers are finished, the applicant has an opportunity to rebut, but only to those issues which were raised by the speakers. And that'll mark the end of discussion. The application will then be taken into committee for a decision. Madam Deputy Secretary Treasurer, are there, or panel members and staff, are there any declarations of interest by panel or staff on the items in this time slot? No. Madam Deputy Secretary Treasurer, have you received any requests for deferral?
Good afternoon, Mr. Chair and panel members. There are actually 3 deferrals for this afternoon. Item 24, 341 Quebec Avenue. Variance number 5 was incorrectly identified on the public hearing notice. Item number 30, 131 Farnham Avenue. There was improper notification. And item 39, 789 Euclid Avenue, which we'll be dealing with later this afternoon, has requested for a deferral.
Number 39, 789 Euclid?
That's correct.
Thank you. Madam Deputy Secretary Treasurer, are there any files to be closed?
Through you, Mr. Chair, see none for this afternoon.
Thank you. So we shall now go to the agenda, which begins with today's item number 21. (2241) Dundas Street West. And on this application, before the panel are the following materials. Those submitted by the applicant at the time of application. 4 photographs received June the 9th of the site. There's email correspondence from Transportation, and there is support correspondence from Taylor Ransom, no address provided. Plus, there is a 45 signature petition in support, signed by the owners or occupants of properties on Dundas Street West, Alhambra Ave, BOUSTEAD Ave, Indian Trail, Radford Ave, and Roncesvalles. So moderator, we shall ask the agent for number 21 to join us, please.
Yes, good afternoon. My name is Robert Smith. I'm an architect representing the clients. My address is 605 98 Richmond Road in Ottawa. I'd first like to thank the committee for considering this application. There are two things that sparked the application. One is change of use, and the other is the addition of the playground in the rear. So,
Okay,
just
Robert,
yes,
I'm going to ask you
Yes.
to hold it there for a moment while I
Okay.
check with my panel colleagues. I'm going to see whether they'd like a presentation or whether they may have questions which they'd like to put to you directly. So, panel members,
Okay.
presentation? Ms. Chan?
I have a question.
Go for it. Okay, so Robert, we don't require a presentation, but we do have some questions for you. Go ahead, Ms. Chan.
Okay, because just have you mentioned that there are two things you're asking, but on the notice, we only have one variance, which is about the parking spaces. But the first one, you said the change of use, should that be also included as one of the variants?
no, the use is permitted. I noted that there were
you said
two
that.
things that sparked the application.
Oh, you do not
the
need
application
to
is,
have.
yes,
I understand. So it's the permitted use.
yes, the use is permitted, yes.
Yeah, I didn't understand it before. Yeah. Okay, thank you.
Yes, okay, so just the one variance. Any further questions of the applicant? Panel members? No, hearing none. Hearing no further questions, we can take this application into committee for a decision. Mr. Salomon, go ahead, please.
Yeah, there's only one variance, and it deals with parking and transportation services. As indicated, they do not have any objections. I believe the variance is minor in nature, and I would move approval with no conditions.
Is there a second to that? It is seconded, Ms. Chan. Moved and seconded to approve. Those in favor, please show hands. And that's a unanimous vote to carry the motion, and the application is so approved. Number 22 is 103 Gladstone Avenue. Here we have the application materials submitted to look at, plus we have correspondence in the form of one opposition letter from Randy Kerr at 18 Beaconsfield Avenue. And moderator, just to check with you, is it correct that we do have one speaker standing by? Okay, very good. So I'll ask the applicant or agent to join us, please, by stating your name.
My name is Ian Cunha. I'm representing the owner of 103 Gladstone Avenue.
Very good. Okay, you have 5 minutes to make your presentation to the panel. Please go ahead.
Okay, Mr. Chairman, members of the committee, we are asking permission to use the existing basement as a secondary suite, converting the house into 3 units from the existing 2. The basement walkout has already been built under a separate permit application, and we have 2 variances, which in my opinion are minor. This project is designed so that we meet all but 2 items in the new zoning bylaw. It's a good design that will give the city 1 additional rental unit without any changes to the size and height of the house, and no visual change will affect the outside of this house other than what we already have a building permit for. I believe we meet the 4 tests of the Planning Act, and we ask this committee to grant us this application.
Thank you very much. Do you panel any questions at this time for the agent? No. Let us go then to the person registered standing by to speak in opposition.
Hi, Randy, you've been unmuted.
Okay, thank you.
Please state your name.
Okay, my name is Randy Kerr. I'm at 18 Beaconsfield Avenue. I'm associated with the Beaconsfield Village Residents Association. We've been active for over 14 years in this historically significant neighborhood with Victorian architecture, much like 103 Gladstone and its nearby neighbors. We have one objection, and that is the pedestrian entrance leading exclusively to a secondary suite not permitted in a front wall of a detached house. The existing front yard pedestrian entrance will lead exclusively to the secondary. We object to this because of the nature of the streetscape, Victorian elements of the residential housing immediately abutting 103 Gladstone, single entrances, some of which have single family housing, some of which are multi-unit rentals, no problem with that. Both types have side and back entrances and internal separation through the main front door access. This building type, both detached and the semi-detached types adjacent to the 103, maintain the flexibility to be used for both housing options, single family housing and multi-unit rentals, with an easily converted back and forth for future owners while maintaining the streetscape. So unfortunately, I couldn't file up my document in time, but I'm sure if you looked at the diagram that the applicant presented, you can see that they're Victorian houses, similar size and scope adjacent to it. So our residents association is concerned about some of these conversions, especially with you know, 3 secondary suites and possibility for more in the laneway side. Residents Association has done some preliminary research in the developer, and this is a development consortium of sorts. We haven't nailed it all down yet, but we're working on it. There's a DAS group that's the developer builder, and Coonage Design has been converting this type of housing to a high turnover rental Airbnb type housing accommodation that undermines the need for permanent affordable housing in this neighborhood and Toronto as a whole. With that second entrance as a secondary suite, we feel that it's automatically going to be designated as an Airbnb suite because of the separate entranceway, et cetera, et cetera. We found that these applicants, this group of applicants, a consortium may not be the right word. They've additionally done 2 other projects recently, 223 and 225 Lisgar. Same situation, they converted single family or multi-unit housing into housing with separate entrances. They're advertising on Airbnb. We've seen the advertisement for $8,000 a month per suite. They do claim that there's a principal resident there, but we have no way of knowing that. So we feel that this type of development is not in the best long-term interests of the neighborhood because it's asking for short-term designs to accommodate short-term rentals. And we feel that the other ones, 223 and 225 Lisgar, went through the same process. They got the main variances accomplished on the main building, and then they applied for 2-unit laneway suites on each property. Okay, so that produces a little mini hotel scenario with possibly principal resident, but possibly just it's a hotel and everything other than in name. So it seems that the main building variances that get out of the way, and then they secure 2 laneway suites. Right now, it seems to be penciled in on that diagram, but we're not. I don't think there's an application for 103. But both 223 Lisgar and 225 Lisgar in 2021 applied after the house was built, applied for the 2-unit laneway suites on a fairly small lot that doesn't provide for permanent housing. It's more for a temporary housing. So our neighborhood's concerned that if this continues, there will be no single family or long-term residents in this neighborhood. They'll all be converted to these type of houses. And I think the fact that there's a control on the front entrance for a secondary suite makes it easier for that Airbnb type rental should be objected to, and we do object to it, and we hope that the committee will see that it's not necessary. Side entrances, back entrances,
I'll
entrances
ask
through
for
the
your
front
final
door,
comment,
and-
please.
Okay, so that's it. So we ask you to please deny the front entrance variance.
Thank you.
Thank you.
Thank you. Panel members, questions for the speaker? Hearing none, we can return now to the agent, who will have an opportunity to speak in rebuttal.
Mr. Chairman, members of the committee, what we're doing here is basically what the city of Toronto is telling everybody that we should do, is to create additional rental units. Whether, like, I don't understand why this gentleman that I was just speaking would say that my client has any intentions of going to Airbnb. I do not, I have no information on that. What we're doing here is basically keeping the existing space. We're not increasing the floor space index. We're not making the house any bigger than what it is right now. We're just using existing space to create a rental unit. This area here is already a very high density. If you go to Dufferin Street, which is just a block away, we're looking at condo buildings that are either being built or already done. So the front entrance, it's actually not visible because it's below the slab of the concrete porch. It's not something that becomes very visible. And to be honest with you, when I was doing the design for the rest of the home, I was not aware that there was a new bylaw that prevented us from using the front basement walkout as our main entrance. So that's why the basement walkout was done there, or we could have done it at the back. It's possible too, but it is built. It's built under building permit. Building permits were taken out. All inspections have been done so far. And like I said, we are doing what the city is asking us to do, which is to provide additional rental units. And in this case, we're doing something that's not going to affect in any way, shape, or form, whether we use this basement for an apartment or we just leave it empty, it's still there. So we ask this committee to grant us this application because I think it's a good space, it's a good unit, and we need these units in Toronto. Thank you.
Thank you. Panel, any questions? I do have one, and that's a comment you just made a moment or so ago. That was yours having said that it was already built.
What's that, sir?
Did you just say about a minute ago that this front entranceway that constitutes the first minor variance, that it's already built?
It's built, but under a building permit. So it was built under a building permit.
Okay. All right, thank you.
So it's not something that we did and
Yes,
we're trying to clean it up. No, this was under a building permit application that was granted to us.
Thank you, okay. Okay, then, if there are no questions for the agent, then we can take this application into committee for a motion or discussion. If anyone, Mr. Reid, go ahead.
Thanks. I think that this is a very minor application. I think the individual who spoke in opposition to the application was more concerned about tenure, and that's not really our concern. I think our issue is looking at the variances themselves and seeing if they're minor and acceptable. And I think these are. I think that front staircase is being screened very appropriately, and the remainder of the works are internal to the house. So I can see no negatives from approving this. So I move approval of the application with no conditions.
Thank you. Is there a second to that motion? It is seconded by Mr. Salomon. Moved and seconded to approve, no conditions. All in favor, please show hands. Motion is carried. Unanimous vote, and the application is so approved. Panel moves along to number 23. 23 King Street East. On this application before us are submitted materials, cover letter from the agent, a number of Committee of Adjustment decisions affecting the property, presentation materials from the agent September 20. There is opposition in the form of correspondence from Peter Nikolakakos on behalf of HOOPP Realty and First Gulf Ontario Street Corporation. Received 15 September. I beg your pardon, that was a typo. I just read, this application is not 23 King Street East, it is 280 King Street East. And that was simply a typo on the sheet that I had. So, to be clear, we are dealing with the application for 280 King East. Okay. Moderator, we have some people standing by to speak in opposition? Yes, okay. So we'll ask the person speaking on behalf of the agent to join us, please.
Good afternoon, members of committee. My name is Andrew Biggert. I am lawyer for the applicant, Alexandria Properties, and I'm here today, quite obviously, excited to discuss this great opportunity for the city with you. And I am here to present a presentation, if you so wish, or to answer questions.
Well, thank you very much. We will ask for your presentation, please. You'll have 5 minutes, and please go ahead now.
Thank you very much, Mr. Chairman. So by way of overview, and just to confirm, I represent the purchaser of the subject property, 280 King Street East, Alexandria Real Estate Equities, Inc., which is a New York Stock Exchange listed company. And I can also advise you that the current owner of the property, their representative is here today. That would be Mr. Smiley from Faskin's law firm. As the committee is well aware, having examined this file in advance of today, the application is to permit one variance and one variance alone. And that is simply to expand the permitted use within the building to allow laboratory uses within the building. There are no variances required to the outside structure of the building at all. It is entirely internal. And just so the committee has an understanding of who my client is and why my client is pursuing this, is my client is a landlord operator in the life sciences industry. It operates as a landlord to some of the most recognizable names in the industries, Pfizer, Moderna, AstraZeneca, to name a few, and has approximately 67 million square feet worldwide of leasable space to members who operate in the life sciences area. And this is certainly an industry that the City of Toronto is hoping to attract. And I'd ask the committee to please make note of the fact that the City of Toronto's Economic Development Department sent a letter in support of this application, noting the shortage of life sciences space within the city and the importance of such development within the city and the need for this type of working arrangements. I also note that this type of development allows for actual work in a building as opposed to a work at home type of development, which is something the city is looking for. So it has the runoff abilities with respect to supporting local businesses when you have people going to work and operating in a building. Now, I can also advise the committee, if I may, that the subject site, 280 King Street East, was operated as a data center for years. And on top of the roof, and the only reason I'm mentioning the top of the roof and the mechanical penthouse is because an objection's been raised in relation to the mechanical penthouse that my client will be constructing on the roof. There currently sits cooling machinery and a mechanical penthouse for what used to be the data center within this building. That data center is no longer operating. My client intends to repurpose a part of the mechanical penthouse where it exists, and also construct an additional mechanical penthouse that is required for the appropriate ventilation within the building. So you can see here in front of you, the lower mechanical penthouse, which is the darker on the roof, is currently exists, and my client will be constructing a new mechanical penthouse within that same area. And then on top of the building, we have the new mechanical penthouse. And I'd like to stress to the committee that none of the mechanical penthouse development requires a variance. My client could pull a permit today to construct the mechanical penthouse that you see before you, and my client today could place a lab anywhere within the building today pursuant to the CR zoning. The only restriction that currently exists that my client is seeking an exemption from is the requirement to be able to put the lab throughout the building as opposed to only within an area that is equivalent to the ground floor area. That's the one and only variance, as you can see by your file. With respect to the 4 tests, just as I'm getting closer to wrapping up here, recognizing my time, the area is designated regeneration area. Regeneration area calls for commercial, live, work, light industrial, and it speaks to also revitalizing areas, reusing areas, and reusing buildings to create well-paid, safe, and sustainable jobs. What my client is proposing is the poster child for what a regeneration area should be. Certainly maintains the general intent and purpose of the official plan. With respect to the zoning bylaw, the use of a lab and office space is already permitted within the zoning bylaw. My client is simply seeking an expansion of the existing use permission within the building, again, solely contained within the building. This is a lab is obviously a type of use that the city is seeking, as again supported by the Economic Development Department of the City of Toronto. And also we have letters of support from Life Sciences Ontario that you will see in the file.
I'll ask for your final comment now, please.
Yes, sir. It is desirable and it is minor. It is the type of jobs that the city is looking for, and minor because it has the variance itself has no impact whatsoever. Thank you.
Thank you. Panel members, we have a number of speakers standing by. Do you have questions now, or should we wait until we've heard from the speakers? Let's wait till we've heard from the speakers. We'll come back. Mr. Moderator, first speaker standing by.
Through you, Mr. Chair, the first speaker may be associated with the owner of the property. We can confirm that.
Okay, then is that Christine Maisonneuve?
Hi, Christine, you've been unmuted.
Go ahead.
Hi, no, I believe Neil will be speaking on behalf of SAS Institute.
You are the registered speaker. We don't show. Oh, so Neil is speaking in support. Okay,
Neil
so
is our legal counsel. Correct.
Very good. Okay, so we're working our way down to him. Very good. Okay, let's go then to the next person.
Hi, Max. You've been unmuted, and you can turn on your video.
Thank you. Just give me a minute to turn on my video. Yes, good afternoon, Mr. Chair, members of the committee. Can you hear me?
Good afternoon. We do hear you clearly.
Thank you very much. Mr. Chair, members of the committee, my name is Max Laskin. I am here today on behalf of First Gulf Ontario Street Corporation, which owns 25 Ontario Street, located immediately north of the subject site. My client, Mr. Chair, members of the committee, is in the process of constructing a 23-story office building at 25 Ontario, as approved by City Council in 2017. My submission to you this afternoon is that this application should be refused. Although the applicant in his presentation focused on the expansion of the laboratory use within the building, the amount of laboratory space requested through this application cannot be accommodated without a substantial increase in what is already a very large mechanical penthouse on this building. And in this regard, I have two main points to make in my presentation. The first, as I will explain, is that the resulting mechanical penthouse, which would be 15 meters in height or nearly 50 feet, results in unacceptable impacts on our clients' lands that are not minor and not in keeping with the intent of the official plan. My second submission, as you'll hear, is that the noise and air emissions that will result from this mechanical penthouse requires detailed analysis in coordination with the other buildings that form part of this block, including that of my client. There are recognized interdependencies between these buildings, as I will explain, and yet there has been no assessment of air or noise emissions with respect to the application before the committee today. And in my submission, a zoning application is the correct process for assessing those impacts. So with that as a brief overview, I want to focus now on my first point relating to the impacts associated with the mechanical penthouse. If I could ask Mr. Moderator to pull up the presentation material that was submitted to the committee, I would appreciate that. And while that's happening, I'll just note that the building on the subject property today already has a very large mechanical space. Thank you, Mr. Moderator. If you could go to pages 2 through 4, I'd appreciate it. Thank you. So this image is an image of the existing building today, already a very large mechanical space with structural features that make it even more prominent. To this existing condition, the applicant proposes to add a further 8.5 meters of mechanical space, resulting, as I mentioned, in a proposed height of 15 meters. And if you could carry on to the south elevation, please, in this presentation, Mr. Moderator, just a few pages down, just to demonstrate the extent of the space added. If you could carry on further, please, Mr. Moderator. Just one level down to the south elevation, that would be great. Sorry, one more down. Thank you. Here shows the new mechanical elements added, one lower element, as Mr. Biggert mentioned, and the upper element, which is an additional 6.5 meters. And that space is going to be separated from my client's office space by less than 9 meters. This extensive increase in mechanical space on what is already a very large and obtrusive mechanical element will obstruct light and views from significant portions of our client's office tower and cannot be considered minor. And further, Mr. Chair, it is not in keeping with the intent of the official plan. The in-force secondary plan for this area, known as the King Parliament Secondary Plan, identifies as a major objective the creation of good quality working and living environments. It also provides that new buildings for any use, not just residential uses, but any use, will be sited and masked to provide adequate light, view, and privacy for neighboring properties. In my submission, Madam Chair, Mr. Chair, this application does not maintain that intent. The increase in laboratory space proposed necessarily results in such a significant mechanical space, and that mechanical space does not allow for a good quality working environment as the official plan intends. Moving to my second point, Mr. Chair, relating to air quality and emissions. This block has been the subject of a detailed and coordinated planning exercise over the last couple of years in light of air and noise emissions resulting from the building at 280 King. And Mr. Moderator, if you could go down 2 slides to the site plan that shows the neighboring properties. Thank you. Here you'll see that the conditions on this block are tight. My client's land is 25 Ontario just to the north, and to the east, 284 King Street East, which is a residential approved building. Both 25 Ontario and 284
Pardon me,
King
I must ask
approved.
for your final comment, please.
Thank you. Both 25 Ontario and 284 King were approved through zoning processes where the emissions from 280 King were central features of those approval processes. And this application before you does not allow for any assessment whatsoever of the impacts of the emissions resulting from this increased mechanical penthouse. The only way to provide for that analysis is through a zoning process. And in my submission, that is the correct outcome for this application, a refusal and an opportunity to undertake the zoning process. Thank you, Mr. Chair.
Thank you. Panel members, questions? Mr. Solomon, go ahead.
Yeah, can you kind of explain to us what are the issues dealing with emissions?
Yes, thank you, Mr. Solomon. So for both 25 Ontario and 284 King Street, the residential building to the east that I mentioned, the existing building at 280 King, because of the significant mechanical, has both noise and air quality emissions. And to maintain a good living environment for the building on the residential building to the east and adequate noise conditions for the office building that our client is constructing, rigorous analysis or further study is required, I should say, in connection with the site plan approval process for 284 King Street, and that is to be done in coordination with 280 King. So based on the emissions of 280 King, 284 King needs to undertake further studies to demonstrate that the conditions are acceptable. And if this application is approved, there would be no opportunity for that analysis to be done to demonstrate that in fact the emissions are acceptable. And with the significant increase in mechanical space, one would expect that additional emissions would result. Yet, Mr. Chair and Mr. Solomon and other members of the committee, there's no information before us today to demonstrate what those emissions are.
Okay, okay. Ms. Chan, go ahead.
My question is then, when they apply to build this mechanical penthouse, they will have to comply with the emission bylaws or any regulations, right? Do they not have to?
So there's no, through you, Mr. Chair, emissions aren't governed directly through bylaws in that manner. They're governed through guidelines issued by the province of Ontario, and those guidelines are exactly the things that are assessed and analyzed in the course of a zoning application. There's no bylaw per se that regulates it directly once approved and constructed.
My question, I have a question here, and then Mr. Solomon next. Does not the fact that the mechanical penthouse is recessed in from the street edge from set back considerably, does that not mitigate to a large degree the sunlight issues that you had mentioned?
It does not, Mr. Chair. Thank you for the question. It does not as it relates to my client's lands, because my client's lands are located to the north of the subject property. And so our client's office building is approved to be built right up to the property line of the subject property. So it's that north condition that directly concerns my client as opposed to the setback from the street.
Okay, thank you. Mr. Solomon.
Yeah. Why do you believe that the impacts would be different than what the current mechanical is already doing in terms of emissions?
Well, I have to say, thank you for the question, Mr. Solomon. Just to start, I have to say, somewhat speculating because we don't have any information before us, as I noted. But the additional laboratory space is going to result in effectively double the amount of mechanical space that's required for the existing use. And Mr. Biggert noted that the additional mechanical space is required to accommodate the type of laboratory uses expected. And so, Mr. Solomon, I don't know for certain because there's no information before us, but I submit to you that we shouldn't be presuming that the emissions would be the same or better if there's no information indicating that, especially if the amount of mechanical space is doubling through the application.
Okay. Okay, thank you very much. Let me ask, okay, we'll go on now then. Hearing no further questions of this speaker, we'll move on to the next speaker. And is that Rosalind Hauser? Or is it Neil Smiley?
Hi, Neil. You've been unmuted, and you may turn on your video.
Oh, thank you. Are you able to hear me all right?
We hear you clearly.
Beautifully. Thank you so much, Mr. Chairman and members of the committee. My name is Neil Smiley of Fasken Law Firm. And as Mr. Biggert noted earlier, I'm here on behalf of SAS Institute Canada, the owner and occupier of the SAS property since 2005, that being the subject property before you. You've heard from Mr. Biggert today the submissions of the applicant in support of the variance application before you, again for a single minor variance to permit the laboratory use in excess of the GFA of the first floor of the SAS property. We agree with Mr. Biggert's wholehearted submissions, and we respectfully ask the committee to approve the application for minor variance as being minor within the meaning of Section 45 of the Planning Act. And I do not want to repeat Mr. Biggert's submissions, but I did want to say, with respect to my friend who spoke on behalf of the property owner to the immediate north, who's building the office building, SAS, the property owner today, could incorporate the machinery that you're seeing on the plans before you and apply, as one of the members suggested, for building permit tomorrow and secure that permit. There is no variance required for the machinery, and I would respectfully submit that the wholesome building permit process at the City of Toronto, the bylaws and Ministry of Environment oversight is what any typical application would use to deal with the issues that our friend regarding the property to the north has raised with you. So I would suggest and reiterate that the variance relates to just adding additional laboratory space that's already permitted in that building, and the mechanical and what you've seen on the plans is permitted as of right. The other processes, building permit, MOE, and whatnot, is there to protect the city and neighboring landowners as with any application. I do have with me, and let me conclude to indicate that I have Mr. Chad Rule of SAS in support of these submissions, who's able to speak to us virtually in case I need to defer to him to answer any of your questions. And those are my submissions, members of the committee.
Thank you. Let's see if there are questions for this speaker. There are none. Okay. So that being the case, does Mr. Rule wish to speak, or only if needed? Only if needed. Okay, fine. Okay then. In that case, we have heard from those that are registered wishing to speak, and we can go back now to the agent speaking on behalf of the agent, Mr. Biggert, who'll have an opportunity to respond in rebuttal to the issues that were raised by that person speaking in opposition.
Thank you, Mr. Chairman. I had requested when I submitted the form that I be on video as well, but that hasn't arisen. But, oh, here we are. Start video has now popped up on my screen. Thank you. Just to let you know that I really am here. It makes me feel better. So just in response to Mr. Laskin, he simply has his facts wrong as he's presented them to the committee. My client's mechanical penthouse is not 15 meters in height. The mechanical penthouse, as we can see on the plans, is going to be 6.5 meters in height plus 2-meter wall for the fans to stop that from happening. Mr. Laskin was measuring it from the bottom of one to the top of the other, which is not what at all is going to happen here. As you can see, there are two separate mechanical penthouses, one on the roof and one below that, that sail coming out from the roof. So his measurements to you are simply wrong. Most importantly, Mr. Laskin himself has come forward today and admitted that he has no idea whether or not there's going to be a noise issue. And the reality is, and this question was asked of him, that all noise issues and emission issues are dealt with by the Ministry of the Environment. They are subject to regulation. They are subject to guidelines. They are subject to enforcement by the Ministry of the Environment. And also, importantly, Mr. Laskin, who is here for an office building, is not coming before you as a sensitive land user. A sensitive land user is the residential building. Mr. Laskin made mention of a building at 284 King Street and some development that is going on at 284 King Street. He does not represent 284 King Street, and 284 King Street, which is the closest residential building, is not here in opposition. So they clearly have no concerns with respect to what my client is proposing. So with that said, I will try, as I know this is reply, so I am keeping it short. This is a matter that should be approved by the committee based upon all of the evidence that has been presented to you today. And I would ask the committee to simply approve this one variance, which is for the internal workings of the building for a use that's already permitted. Thank you.
Thank you. Let's see if the committee has questions for you. Mr. Salomon, go ahead.
Does the additional mechanical space, does that need to go through site plan review through the city?
It is not subject, through you, Mr. Chairman, it is not subject to site plan review, but I do note that it is 8 meters away from the 25 Ontario Street property as it is. The plans were submitted to the city, and we did go through the zoning review examination, and the only thing that was noted for the variance was the obviously the lab issue with respect to the internal workings of the building.
My question for you is this, where the building is proposed to go from 1 story of lab use to 6 stories of lab use. Is it those additional 5 stories of lab use which are triggering the need for increased mechanical capacity?
The increase, Mr. Chairman, the increased mechanical capacity is derived from the lab use expanding, yes, but it also then results in the modernization of the mechanical penthouse from the old system that was there with respect to the data center that effectively had jet engines on the top to keep the data center cool. So yes, but it's a brand new mechanical penthouse structure that will be constructed there, directly related to the implementation of labs, yes.
Does the existing old mechanical penthouse remain an operating mechanical facility, or does it just go dormant?
The space where the current mechanical penthouse exists will be dismantled and then rebuilt as part of the new mechanical penthouse, if that answers your question, Mr. Chairman.
It does, yes, thank you. Okay, further questions by any panel members? I'm hearing none. So at this stage, we can take the application. Oh, Ms. Chan, go ahead.
I don't have a question. I'd like to make if we are in committee, I'd like to make a comment.
Well, we're just going into, yeah, we are in committee now. Then, so please go ahead with your committee, with your comment.
Actually, thank you for the explanation by the applicant. That's the only concern that about the air quality and all. And he explained that they are subject to all the regulation and the Ministry of Environment approval. So I'm okay with that, and we are looking at 1 variance, and I have no problem, and I can support this application.
Thank you. Any other comments? Anyone ready with a motion? Ms. Chan, go ahead.
I would like to move a motion to approve this application with no conditions.
Thank you. It is seconded by Mr. Reed. It is therefore moved and seconded to approve the application without condition. Those in favor, please, show of hands. And that vote is unanimous. It carries the motion, and the application is so approved. Thank you. That takes us on to number 24 on our agenda. Which is 341 Quebec Avenue. Before us are materials submitted with the application, photographs of the property received in June, a planning rationale from the agent received in August. There is comment from Urban Forestry, and there is support correspondence in the form of correspondence from 345 Quebec from Richard Decter and Loretto Freire.
Through you, Mr. Chair, this is one of the applications that is required for deferral. Variance number 5 was incorrectly identified. It is a staff error, so it is something that will have to be
Thanks for reminding me.
recirculated.
Thank you for reminding me on that. Okay. So, let's have the applicant join us, please.
Hi, Julia. You've been unmuted.
Yes, we're going for a deferral on this project.
Okay, let's just begin, please. Just state your name.
Julia Burke, B-O-U-R-Q-U-E. I'm the agent for the owners at 341 Quebec Avenue.
Very good. Okay. So the Deputy Secretary Treasurer has given us some background on the rationale behind the request for deferral. I just need to hear generally from you what your reasoning is, please.
I'm sorry, for the deferral?
The reason for the deferral. Yeah, the reason for
the deferral. Well, I guess the city, the letter that went out to all of the homeowners around our client had a mistake in it, and they feel that they need to reissue that notice. So
Thank you.
we're fine with that. They've given us a date of October 12th that will be verified, so we're happy to come back, both the client and myself.
Now I understand. I'm sorry, I didn't understand that the error that's involved is originated with the city. Okay.
Yes, it did.
Now it all makes sense to me.
Okay, good.
Very good. Okay.
Good.
Mr. Chairman, can we just ask the applicant to indicate what should the correct numbers be for variance 5? Just so everybody's aware.
I'm sorry, I don't have that right in front of me. The city issued that to me. I would have to go back to my file to find that. It was in the original zoning notice. So the original zoning notice had the proper numbers, and it was just a glitch on their own system. So I'm sorry, I don't have that right in front of me right now.
Through you, Mr. Chair, if I may help, I do have that in front of me. So the maximum total floor area of all ancillary buildings or structures on a lot is 40 square meters, and the proposal here would be 111.51 square meters.
Okay. Quite a bit more. Right. Okay.
Right.
So panel members, looking to you for a motion with respect to deferral, please. Mr. Reed, please proceed.
Thanks, Chair. I'd like to move deferral of the application to allow for proper recirculation.
Thank you. Second on that? It is seconded. Mr. Salomon, all in favor? Motion carried. And the application is deferred. Number 25 is 448 Oakwood. On 448 Oakwood, we've got applicant materials. There is an order to comply issued in April 2022. And there is email correspondence from transportation. So let's have the agent join us, please.
Good afternoon, Sir Chair and committee members. My name is David Eagleman. I'm a planner here on behalf of the owner. And can the committee hear me?
We hear you well, clearly, David. Yes, you're good. I'm just going to ask you to stand by for a moment. I'm going to check with the panel members whether they have questions for you, whether they'd like a presentation. Panel, questions, presentation? Ms. Chan, go ahead.
Yes, you asked us to legalize the conversion without a permit. Do you know
Ms. Chan?
the reason why?
Ms. Chan,
we do not
somehow,
have a permit?
Ms. Chan, just let me interrupt you for a moment. Somehow your transmission is sort of on and off, on and off, on and off. Something's loose, or because we can't understand you as a result.
Can you hear me now?
Yes, it's better. It's louder now. Yes.
Okay. My question is that this has been built and without a permit. Can you tell us why that we did not have a permit?
Yes, through you, Mr. Chair. A permit was issued for the construction of the building itself. So that is why there are no variances being requested for the actual building footprint of the existing building. So that the construction of the building was permitted and constructed with the benefit of a building permit. It was only the fact that there were units that were built within the existing building after that permit had been issued, which were not compliant with the zoning bylaw. And while I can't speak to the specific reason as to why my client did construct those units without a permit, I can say that as soon as he was issued the order to comply by the city, he followed all regular processes, reached out and retained my services to go through the appropriate processes, And we are now before you with to demonstrate that the proposal meets the 4 tests.
Thank you very much. And at this time, it would be appropriate for me to comment to all those watching and listening. The Committee of Adjustment in no way condones construction without permits. The permit process is essential to an orderly development of the city. Sometimes, however, as in this case, applications come before us which involve construction that has already taken place. So, the Committee of Adjustment is not vested with punitive powers. We are required to approach this kind of application specifically as follows. We have to look at it and think of it as if it had not been constructed, as if, like all the other applications we're dealing with, it's a proposal. And then we ask ourselves whether or not, according to the 4 tests that we apply, it should be approved or refused. So in other words, it gets the same treatment as every other application as we decide whether to refuse or approve. Okay, Mr. Salomon, go ahead, please.
Yeah, I just wanted to ask a question. Is an apartment building a permitted use under the zoning?
Through you, Mr. Chair, the subject property is within a residential multiple zone, which I believe does permit apartment buildings, but yeah, so it does, the actual base zone does permit apartment buildings. However, this specific zone, which is applicable to the property, only permits 2 units. So therefore, the actual building type of an apartment building is not permitted on the property. However, I will note that there are many buildings within the area that are apartment buildings or multiple unit dwellings. And just north of the subject property, specifically at 458 Oakwood Avenue, there is a 5-story building which contains multiple dwelling units, likely I can't confirm the exact number of dwelling units, but it is likely greater than what is being proposed through this application. Okay. And there are many other within the area.
So we'll ask, I have one final question on my part for you, and that is, explain to us why, where 2 units are permitted, why 5 units is desirable and appropriate.
Yes, so through you, Mr. Chair, it is my opinion that the variances being requested are minor. As I said, there is a multi-unit building just north of the subject property at 458 Oakwood Avenue, and there are many other buildings on Oakwood Avenue with multiple dwelling units exceeding the maximum permitted number, which is 2. I will provide a few examples of those. There are 3 dwelling units.
No, you don't need to do that. No, okay, I get your point. Okay.
If I may add, through you, Mr. Chair, I'll just say that the committee is most likely aware, the city is currently going through the expanding housing options in neighborhoods work, which is looking to permit multiplexes throughout all areas designated neighborhoods. And once that work is complete and the official plan and zoning bylaw have been amended, this application would only be requesting 1 additional unit over what may be permitted as of right in the near future.
Very good. Any further questions, panel? Let's take this one into committee for a decision, please, or a motion if someone is ready. Mr. Reed, go ahead.
Thanks, Chair. I'm happy to start. I do think that this stretch of Oakwood does have, as the applicant said, a significant number of multi-unit buildings. And this building itself is of good size, I think, and that goes a long way to providing good-sized units. It's not like these are tiny units jammed in a smaller house. I think that this this building was built large and then probably filled up for that way. But I think what has resulted is a decent group of apartments on this site. So I think it's supportable. I think the variances are minor, and Yim has something to say, I think.
Ms. Chan?
Yes. My opinion is that I agree with most of what Peter said, but when I really look at the plan carefully, although the upper units are good size and good quality units, but when you look at the basement units, it's 2 units. And also they call the secondary, to me it's a bedroom because it's designed such as the other bedroom, but they call it playrooms, have no windows. And even if I support the approval of this application, I'd like to mention this. This is not a good quality apartment when you have one of the bedroom, there's no window. And also the total windows for these units are just very small and just very few. And I do not think this the basement should be just 1 unit, not 2, in my opinion.
Thank you. Mr. Solomon?
I would agree with Peter's comments. I think this is a 3-story building, and I think it's appropriate to have that many units in this building. There's no further expansion to the outside of the building or the building structure. And I don't see anywhere that we can regulate the quality of the type of unit. And so I would be supporting this.
Thank you. I can support it
The
also.
I think there's whether it's a bylaw or regulation that you have to provide a window to all the bedrooms. So I just mentioned it only because I think that they by calling those rooms playroom, they just try to get around the regulation.
Okay. Who'd like to go with the motion on this application? Mr. Reed, please.
And Jim, I understand what you're saying. And I'm just hopeful the building code will take care of that. For the reasons I outlined before, I'd like to move approval of the application with no conditions.
Thank you. Second to that, it is seconded. Mr. Solomon. Moved and seconded. Approval. Those in favor, show of hands, please. That's a unanimous vote to carry the motion, and the application is approved. We go on to number 26, 232 Willard Avenue. Before us are application materials, comment from Urban Forestry in the form of a staff report, 5 form letters in support. Owners, occupants, 222, 226, 230, 234 Willard, plus 69 Ostend. In opposition, from Nicholas Singh of the Swansea Area Ratepayers Association, received 15 September. So we'll move on here to have the agent join us, and I'll just check with the moderator. We do have one person standing by. Okay, very good, thank you.
My name is Mike De Oliveira. I'm here representing 232 Willard Avenue. I'm with Replacement Design located at 911 Davenport Road.
Good afternoon to you. You have 5 minutes to present your application to the panel.
So actually, I'm going to make this short. We're actually hoping to receive a deferral at this time based on the comments from the community and the notes they've given where they reference there's possible issues with the zoning notice that was given by the city. We haven't been able to confirm with the zoning examiner, but given light of these possible missing variances and some of the concerns, we're hoping to have some further dialogue with them in the zoning department to satisfy these issues and come back at a later date.
So just to be clear, this is the application for 232 Willard Avenue, and you are asking panel to consider a deferral.
That is correct.
Okay, let me then go and proceed on here to speak with and your reason is, I'm sorry, your reason is for further consultation with neighbors?
For further consultation with the opposition as well as city staff due to possible missing variance.
Okay, thank you. Okay then, moderator, I'll speak now to the one person standing by in opposition.
Hi, Nicholas, you've been unmuted.
Good afternoon.
Thank you.
Good afternoon.
Yes, good afternoon, committee members. It was our letter that suggested that there might be a deferral in order to sort out some of these issues. We would be happy to work with the developer owner to rectify some of the issues that we do see with the plan and also to get clarity from zoning. So we are in agreement with the deferral, if that's going to go ahead. Otherwise, I can do a further presentation.
Thank you very much. That clarifies things for us. So, no, the decision here, I think, needs to go to the panel now with respect to whether or not to defer. So we'll just go back to the panel. Panel members, there is a request to defer on this one. And the representative of the Ratepayers Association is fine with that. So it really is up to us now. I'll look to panel for a motion to go ahead or to defer. Who'd like to go? Mr. Reid.
Thanks, Chair. I'd like to move deferral to allow the applicant time to confer with city staff regarding potentially missed variances and to consult with affected neighbors.
Thank you. Second for that, please. Is there a second? It is seconded, Mr. Solomon. Moved and seconded to defer. Those in favor, show of hands, please. Motion is carried, and the application is deferred. That moves panel along to number 2745 Doncaster Ave. Here we have the materials that were submitted by the applicant to the city, and we have some further presentation materials from the agent 12 September. So, agent, join us, please.
I'm Shahid Dhanavati, and I'm from 1304 Woodbine Avenue, and I'm the agent for this proposal.
Good afternoon. Panel members, questions for this agent? Anyone? No? Okay, then. Hearing no questions, we can take the application, I think, into committee for a motion.
Thank you.
Anyone ready to go forward with a motion on this application? Mr. Salmon, go ahead, please.
So this is a small lot, 25-foot frontage. What's being proposed is a 200 square foot addition in the attic that's being counted as FSI. I think the variances are minor in nature, and I would move approval of the variances with no conditions.
Thank you. Ms. Chan seconding? It is seconded by Ms. Chan. Moved and seconded to approve. All in favor, show of hands, please. Motion carried. The application is approved. Number 28 is 80 Bude Street. On 80 Bude, we have submitted materials, plus there's a staff report from Urban Forestry. Let's have the agent join us, please.
Good afternoon again, Sir Chair and committee members. David Eagleman, 900 the East Mall. I'm a planner here on behalf of the owner from Design Plan Services, Inc.
Thank you very much, David. Just stand by for a moment, please. Moderator, I'm showing one additional person registered to speak at 86 Bude. Is that person standing by? Do we happen to know whether that person is speaking in opposition or support?
Sorry, through you, Mr. Chair, we'll have to confirm if the speaker is in opposition or in support.
Well, let's do that now.
Hi, Kathy. You've been unmuted.
Hello.
Hi, yes, I'm here, yes. Sorry, I didn't have time to check the plan and everything, but so I just prefer to listen now, and I don't have any opinion for now.
Okay, so you just want you're listening in interest. You want to hear what's going on.
Right.
Thank you. Okay, very good.
Thank you.
Let's go back then to the agent. Agent, I'm going to check with my panel colleagues. Do we have any questions, panel members, for the agent? Not hearing any. No need for a presentation. Okay. I'll look to we can take the application then into committee for a motion. Mr. Salomon, go right ahead.
Yeah, so this is an existing undersized lot with a old bungalow on it. You can't change the size of the lot. That's what it is. I think the variances are minor in nature, and I would move approval of the variances subject to urban forestry condition number 3.
Thank you. That is seconded by Mr. Reed. Moved and seconded. Approval. All in favor? Motion carried. The application is approved. Thank you. Number 29 is 88 Farnham. Here the committee has before it submitted materials, cover letter from the agent, September, arborist report, May, and support correspondence from 93 Balmoral, received September. And we shall ask the agent to join us, please.
Hello, Mr. Chair. Jay Smith. I'm the agent for the application.
Thank you. Okay. Panel members, any questions? Mr. Salomon, go ahead.
I had a question about the FSI, and is the FSI high because the basement is being counted as part of the floor space?
Through you, Mr. Chair, yes, it is, because the existing basement is included in the FSI. The proposed basement we're actually lowering, so the proposed basement is not included, but the existing is.
Good distinction. Thank you. Mr. Salomon.
And a question about the rear third-story balcony deck. Is there going to be privacy screening on the two sides of that?
Through you, Mr. Chair, in my cover letter, we said we would not object to that being a condition of the 1.5 meter privacy screens on the east and west side of the deck. That would be completely fine with the owners.
Thank you.
Very good. I think we're ready to take this application into committee for a motion. Ms. Chan, go ahead.
Yeah, the only concern is is the privacy on the upper deck, and I think with the condition to put a privacy screen, I'm okay with this application, and I think that the variance is minor in nature. That's it. Yeah.
So there's a motion to approve with privacy screening as a condition. Second to that motion? Mr. Reed seconds.
Sure. Chair, could I just add something, please?
Yes.
I think there's urban forestry 2 that came in the supplemental materials as well.
I missed that one. Yeah. So yeah, forestry condition 2.
I think it, unless I'm mistaken, but.
Well, let's just go slowly for a minute while staff is checking that. Thank you, Mr. Reed.
Through you, Mr. Chair, perhaps Mr. Reed is thinking it's part of item number 30 and not this item, which is number 29.
Possible, Mr. Reed, but both of these are on Farnham Avenue. Number 30.
Pardon me, yeah,
Not a
I'm
problem.
just seeing that. I was one off, excuse me.
Not a problem.
Okay.
Thanks.
Okay, so forestry does not need to be in this, should not be in this motion. Okay, so we're back to our original motion, which is
The
approval,
privacy screen is conditioned.
privacy screening. And that was seconded, that needs to be seconded, is seconded, Mr. Reed. Okay. Moved and seconded, therefore, to approve. All in favor. Motion carried. Application approved. Okay. Now, number 30 actually is an application on which a request to defer has been entered. So, it is 131 Farnham. And we'll ask the agent please to join us.
Through you, Mr. Chair, I'm still trying to contact her. She was online earlier.
Take a moment now, and if we don't get her within a relatively short time, we'll move on to the next application and circle back to this one a little later.
Through you, Mr. Chair, this is the situation where there were lands that were left out of the circulation area. So it's improper notification.
Okay, so
Yes, so this application has also been rescheduled for the October 12th hearing. So this is automatic deferral.
we don't need to, okay. So panel, we don't need to have the agent with us because the error that led to the deferral is on the part of the city. So I look to panel for a motion with respect to this application. Mr. Salomon, go ahead.
Yeah, I just have a comment on this because I do note that the applicant did indicate that there were going to be changes or revisions to some of the variances as well. And just that if this is being deferred, if that a revised notice be circulated to everyone in the circulation area as well.
Through you, Mr. Chair, yes, staff will work with the applicant to ensure that the revised notice is properly sent out.
Okay, then. That can be in the motion. Very good. That's your motion, Mr. Salomon?
Yes.
Is there a second to that motion? Mr. Reed seconds. Moved and seconded to defer. All those in favor, please, show of hands. And the motion's carried. Number 30 is deferred. Number 31 is 119 Billings. And on 19 Billings, the only materials before the panel are those submitted at the time of application, plus 4 photographs of the property received the 1st of September. Let's have the agent join us, please.
Mr. Chair, my name is Enzo Lacasano. I am the agent for this application.
Thank you. Okay. All right then, panel members, presentation on this application? Questions? I have a question, Mr. Lacasano.
Yes.
You're asking to maintain, is that the same as legalizing? In other words, is this an existing?
Yeah,
It's an existing.
that's correct. There's a photo of it on A1. I don't know if staff can pull that up. No, it's not part of the. Those are just showing examples of other properties that are across the street. Yeah, there you go. Yeah, they're on the bottom left. That's to maintain an auxiliary building, which is a shed with a child's play space above it.
Okay.
Again, this was an existing structure that was on the property before this owner had purchased.
Okay. And, okay, very good, and, okay. Okay, I have another question. Is there a laneway on the other side of that fence, or not?
No, there's not.
There's not, so it might be construed as a garden suite.
Yeah, we went back and forth with the examiner, with a ceiling height of 4 feet, of less than 4 feet up there. It'd be a tough garden suite, maybe for the raccoons.
How would a child get to that second floor?
There's a small ladder. You can just, it's just out of that photo.
Right.
It's a very steep ladder that they climb up. It's almost like a climbing wall.
Okay.
And then they slide down the pole.
Okay, thank you. Okay, panel. Panel, there are no further questions for this applicant. Anyone ready with the
Sorry,
motion?
Mr. Chair, the application was initially just to enclose the existing porch area, but the examiner made a very big deal about this. So we decided to include it in this application as well.
It was to enclose the main front porch?
Yeah,
Oh,
that's
okay.
the main application.
Right, okay.
That was the initial application, but we then went on with the examiner and decided that we would just include the auxiliary building as part of this application in order to legalize.
Thank you. Okay, I think we can take this one then into committee for a motion. Mr. Reed, please.
Thanks, Chair. Well, I do agree that the two-story ancillary building is not appropriate. I think this one is mitigated by the fact that it has a very small footprint and a very, very small, short second floor, as well as it slopes down to the back and is neighbored by another shed. So I think the impacts of that shed are very minimized, and then enclosing the front porch is something that happens a lot in this stretch. So I see no negative impacts to these variances being requested. I think they're minor, and I move approval.
Thank you. Second to that motion? It is seconded, Mr. Solomon. Moved and seconded, therefore, to approve. Those in favor, please show hands. Motion carried. The application is approved. We come down to number 32, which is the final application in this segment of today's agenda, 94 BOUSTEAD Avenue. On 94 BOUSTEAD, we have the agent's or the applicant's submission. We have correspondence both in support and in opposition. In support, from 74 Indian Grove, 8 Rideout, 92 BOUSTEAD. In opposition, from 78 BOUSTEAD, 63, 76, 88, and 90 BOUSTEAD, and 51 Radford Ave. So we shall ask the agent to join us, please.
Good afternoon, committee members. My name is Allison Milne, and I'm the owner and agent for 94 BOUSTEAD Avenue.
Good afternoon to you. You'll have 5 minutes to present your proposal to the panel. Please go ahead.
Okay, I am actually an interior designer in the Roncesvalles neighborhood and have participated in quite a few COA hearings over the last 10 years. And this home is my own home, and myself and my family are excited to move into the neighborhood once this renovation is completed, raise our children here and become part of this great community. As you have mentioned, we've received a number of letters both in opposition and in support of the application, and I want to address these items at this time. Just to note, I have contacted those who did send in letters of opposition. I went to the houses yesterday, dropped off some paperwork to explain the proposal and provide my contact information if they have any further questions. The main issue that's been brought up in these letters of opposition is regarding the massing of the rear addition. The permits that have already been issued for this house were issued back in January 2022, permit number 221017777, which allowed for us to build the structure exactly as we have done over the past 9 months. We were within the allowable zoning parameters in terms of setbacks, height, and square footage. The permit GFA brought us to 0.58 times the lot area, which has been built. During construction of this, we realized that the third floor attic, which has been built at this point, was a lovely size, and in order to access it, to add a staircase, finish it, or use it as livable space, we'd be over on our GFA. This is what triggered this variance, which will take us to 60.77 meters squared over the square footage allowable. And that takes us to 0.72 tons of lot area. This inclusion of the third floor into the GFA has no effect on the massing or of the existing addition at all, which was allowable as per the permit. Regarding the heritage of the beautiful house, there's been a lot of questions about that in the letters of opposition. We purchased the house because of the history. The face of the house is not changing at all. Neither are the side walls that take the house to the existing structure. It's really important to us to honor this architect, and that's why we have not changed anything. We've worked very closely with the Historical Foundation as well to make sure that we are achieving that. Things like maintaining the original fireplace nook that Eden Smith was known for, the original exposed ceiling beams, anything we can. The other 4 variances that are on this pertain to the location of the storage shed at the back of the property, as we have asked for it to be closer to the property line at both the north and the east side of the property in order to maximize the yard space. Basically, there's a huge tree on the corner of that lot that you can see, which we want to stay away from, and that's the northwest corner. That's why we've asked for the shed to be pushed slightly closer to our property line in the corner. All that being said, there was one objection there and letter that came from, I believe it's 51 Bradford, yeah, which we have not addressed yet. I didn't meet with him. I'm not sure if he's on this call or not, but I am willing to remove that variance if he's adamant, and I will move the shed back in towards the house. That would eliminate variance number 3 and variance number 5, and we could comply on those if that's something that is meaning a lot to him, which it appears it really is. So I want to make sure to appease that one.
Yeah, we're not. The committee's not here at this time to to sort of assist in these negotiations. If you want to remove those variances, you may do so, but we would look to you to make that call and to instruct us to remove them.
Okay.
So but I'm not telling you should. I'm saying you need to decide and to inform us.
Okay. I'm just the shed just on the other side, which was the east side, complies with the zoning. It complies with the zoning in terms of its height and size. And we do have a letter of support for how close that shed would be to the property line on the east side. Yeah. So I think essentially, I do find these very minor in terms of the variances, and I hope that you agree and find them minor in nature as well.
Okay, so from that, I do understand that you are letting the variances stand as they now appear.
No, we're gonna take 3 and 5 out.
Pardon me. Okay, this is important. So we are
3 and 4.
Yes. 3 and 5. So 3 basically is stating that we're close to the property line, we were asking for 0.1 meters, but we are willing to go back to the 0.3 meters, which would not trigger the variance.
I'm sorry,
And-
you don't need to explain, no. We only have 4 variances on the notice.
Through you, Mr. Chair. So the notice is up on the screen now. And so perhaps the applicant is referring to number 4, but the second part of number 4, the eaves of the ancillary building shed will encroach 0.18 meters into a building setback and will be located 0.02 meters from the side east lot line. Is that the one that we are removing?
No, it would just be the north lot line that we
Okay.
would be changing,
Okay.
not the east.
Okay, so then the first part of variance number 4.
Correct.
As well as variance number 3 is being eliminated as well?
3 is saying the minimum, 3, yes. Sorry, I'm having trouble reading here.
But
We
that-
have a different
that is
document.
to the
Take
east
your
side
time,
lot line.
yeah, slow down, take your time, because we are going to be amending the wording, and this will be what we'll be voting on, and so it's important that we get it right.
No, so it won't be number 3. I'm sorry, we have a different document in front of us for variances.
Okay.
It would be number 2 and the first part of number 4. So it just pertains to the rear yard setback, which was the concerns from 51 Radford.
Okay, so we are going to delete, at your request, variance number 2, and we're going to take out that first chunk
Of variance number.
Variance number 4.
Correct.
I think we all understand each other, and staff are now capturing that so that we have it. Mr. Salomon, yes?
Yeah, I had a question also about the purpose, the way it's described. It talks about a rear 2-story addition. But I think, just to ask the applicant, that rear 2-story addition has been already built under a building permit. So this variance application is not dealing with the rear 2-story addition?
That is correct.
So should that be removed then from the description of the purpose? So it,
Yes, we absolutely thought this was confusing as well. And I think this is part of the problem with some of the neighbors that I spoke with yesterday, because they found that wording very confusing.
Through
They
you,
were-
Mr. Chair,
Just
variance
to-
number 1 relates to floor space index.
Correct.
So that would be including everything.
I guess my question is, the purpose though isn't to add, under the description, isn't to add a 2-story rear addition. It's to add a 3-story addition.
It's to finish the attic space, correct. It's to basically add an interior staircase to access what's the attic that's already been built and approved.
Okay, so let's go very slowly here on the purpose. So again, we get it right. Right now it reads, to alter the existing 2-story detached dwelling by constructing a rear 2-story addition. Should that phrase come out?
Yes, that's the part that was very confusing.
Okay, we take that phrase out, so it'll read, to alter the existing 2-story detached dwelling by...
Yes, this makes much more sense.
Anyone have any suggestions here on wording?
Through you, Mr. Chair, I wouldn't spend too much time on this purpose, because at the end of the day, it's what is going to be existing on the site. And the plans are showing proposed second level, proposed ground level with the additions. And
Okay.
so I don't think it's going to cause issues to have everything included as part of the purpose, because that'll be the complete construction at the end of the day, right?
Panel, Mr. Salmon, makes sense to you?
That's fine. It was just confusing to me. I was just expecting that there was going to be a rear addition being built, but I understand what is
That's
happening.
exactly, yeah, what everybody
Well-
in the neighborhood was asking.
We could change the word constructing to maintaining. Would that do it?
Yeah. Yeah.
Is the second story rear addition complete?
It is not, the interior is not, but it is built.
under a separate building permit?
Correct.
Then through you, Mr. Chair, we will just revise the proposal to read to alter the existing two-story detached dwelling by constructing a third-story addition in order to convert the attic into additional habitable space.
Very good,
And then
okay.
also to construct an ancillary building shed in the rear yard.
Very good. Okay. Sometimes it takes us a minute to get to where we need to be, but it's worth the effort so that the ultimate result reflects everybody's intention and understanding. Okay, so I think we now have the actual variances and the purpose done. So that's what we're dealing with. That's what we will be voting upon. Now, so we, I'm afraid, got into your present. I'm not sure if you'd begun your presentation or whether we were still getting started, but I am at this stage going to allow you 4 minutes to make your presentation, please. If you have
I
if
think I
anything-
was complete. That was what I wanted to say to everyone.
Okay. Very good, thank you. All right then. So now we can go to the person standing by. We have a number of speakers in opposition standing by. And I'll just begin by outlining to them, I hope they were keeping track of what we were just sifting through with the applicant, because that is the proposal now, which is before the committee. It's now revised, as you've just heard it revised. So, first speaker in opposition.
Through you, Mr. Chair, we have a total of 5 speakers in opposition.
Thank you.
Hi, Donato. You've been unmuted, and you may turn on
Have
your
I been
video.
unmuted?
Yes, you're with the panel now.
Okay. Thank you very much for allowing me for this presentation.
Please state your name.
My name is Donato Baldessera. I live at 90 BOUSTEAD.
Go ahead.
I'm a longtime resident of the community. I've lived on Rideout Street and on BOUSTEAD for roughly 46 years. And some of the neighbors who are also in opposition have been here far longer. My wife and I have been friends and neighbors of the previous owners of 94 BOUSTEAD, so the property is well known to us inside and out. What they have done with the construction is they've more than doubled the size of the building. But I also understand that we're not here to, since it's been built by permit, that we're not here to do anything with that. My understanding was that the only reason that they're asking for a permit on the building itself is because of the staircase requiring them to elevate the ceiling and give them adequate access to the 3rd floor, which I don't think we can do anything about now. I've long admired the arts and crafts style of the Eden Smith House and in general the special presentation of this 94 BOUSTEAD to the street with the stone wall, the wooden arch, and the large tranquil gardens in the rear, which will now be gone. Specific to the application, the 2 letters of support from residents on Rideout and on Indian Grove, neither one are within sight of this property, and their enjoyment of their properties can in no way be impacted by your decision. In my mind, they are irrelevant and therefore should be discounted. I've lived on Rideout Street across from number 8, and I know that they cannot see this building unless they stand on a ladder in the middle of the road. To the minor variance regarding the increase of floor space index, as I've said already, the applicant has already built the enlarged space. How you deal with that, I don't know. Having watched your entire hearing today, I don't think there's anything you can do about it. As to the setbacks for the shed, it should be noted that this is not a simple shed. It's a brick structure, 14 feet by 7.6 7 feet 6 inches by 12 feet high, and is made of 2 rooms and will require a concrete pad. This is the current iteration of this shed. It's 105 square feet. Previously, it was a 10-foot by 7'6" in one of the earlier drawings. My question is this a shed, or is it intended to house the mechanicals for the pool, pump, and heater? There's no indication of any of that. In my letter of opposition, I stated that it required a full length, and it's been clarified to me with the paperwork that was given to us by the current owners that they intend to put a full height fence the entire length of the property. It did not indicate that on the other drawings. You cannot see it from the site plan. So that was part of my opposition. I wanted a full height fence the whole way. And I'm happy that they are doing that. I don't see the reason why, if they can move to accept the proper, the existing setback for the north fence, why they have to encroach on the east fence. As to the actual use of this shed, if it is not intended for the mechanicals for the pool, which they are intending to build, then it will be just a very high quality shed, which I have no issue with. But the location of it, I see no need for it to encroach on the setback on the east wall. My lot is an L-shaped lot. It goes across the back of number 92, and it touches the last 10 feet of 94's lot, touches my lot. So it does impact me directly. My question is, if you put this shed here with the location of my shed, what's going to happen in terms of the drainage around the structure, given that the lot has a 38% hardscape as it stands in the plans? And in my view, setbacks are established for good reason, one of which is to anticipate future needs, such as access for service.
I shall ask for your final comment now, please.
The only way to deal with this is to enforce the existing setbacks. There is no need for any variance concerning the placement of this shed. The lot is big enough. It is one of the largest lots on the street to accommodate the existing setbacks without endangering the health of the pine tree, which they claim is the reason for putting it to the east side.
Your time is up.
My final statement is there is no question of necessity here. It is a question of want. There is no need for the COA to fulfill the applicant's wishes.
Your time is up. Panel members, questions for this speaker? Hearing none, we'll move on to the next speaker.
Yes, hello.
State your name, please.
Yes, hi. My name is Rimas Kalinauskas, and I live at 51 Radford Avenue.
Very good. Go ahead. You have 5 minutes.
Yeah. So again, recognizing what Donato just mentioned in terms of the permitted floor space, I guess again, it doesn't look like we can deal with that here. But I guess my question is the ancillary building considered as part of the floor space? And if it isn't, I think it should, because my big concern is drainage and how you manage drainage. To me, it looks like this project is, if you look at all the paved area and the constructed area, it looks like probably 80% of the property will be paved between the patio, the pool, the ancillary building, the asphalt driveway, and then where is all this water supposed to go? And again, I'm not positive, but it looks to me like if you look at the other map that shows where the buildings are located, and I know from experience, it'll all be draining into my neighbors and my backyard. So that's why we definitely support Donato, and we I guess echo his view that there's no reason for the setbacks. The property is double the size of most of the residents in the neighborhood. This will be a monster home that they're constructing here, and well, I guess it's already been constructed. And then who's going to be responsible when all the drainage of this property ends up in my neighbors in my backyard or into our basement? So I echo Donato that I don't think we should allow these the setbacks, and they're not minor. When you're sitting on a 24-foot lot, these are major. They have a 50-foot lot, so there's lots of room to redesign things and to move things around. And again, I echo Donato's concern about what this shed will be used for, the size of it. It looks to me like it's 2 sheds in one, and I don't know if that's a way of getting around some of the rules or not. You know, is this going to be a noisy shed with filtration equipment? We're not sure. Is this going to be a cabana where people are going to be partying? And so again, how's noise going to be addressed? But so those are my comments. Again, it's a neighborhood with lots of trees and vegetation. This is going to be paved over. So those are my concerns. Thank you.
Thank you very much. Questions, panel? No. We'll move then to the next speaker.
Hello, my name is Robert Meddings. I live at 78 Bousted Avenue.
Hello.
Oh.
You're with the panel. Go ahead, Robert. You have 5 minutes.
Oh, okay. My name is Robert Meddings. I live at 78 Bousted Avenue. I'm the husband of Wendy Hughes, who forwarded a letter of objection. My background is in architecture and building, and I've lived on this street for over 35 years. One thing both the 2 previous speakers have said quite a few of the things I was thinking, but one point was that the applicant was concerned about the tree. If she was concerned about a tree, why was she building a swimming pool? That would have the biggest effect on any tree anywhere. As to the design, I cannot understand why the designer did not build a 3-story addition that would comply with the coverage requirements. She chose the maximum allowable distance for setback, and then put a large, massive mansard roof over this addition. And that, as she stated, it created an opportunity for additional space on the 3rd floor. And she said that this did not affect the massing. Well, I guess the neighbors feel that this roof is completely inconsistent with the neighborhood. And the reality is she could have built a low profile roof that would butt into the original roof on the house. And if she needed access to the attic, she could have created a dormer on the attic of the original house. As it is, we're left now with this monster house in our backyards. Basically, that's all I have to say. Thank you.
Thank you very much. Panel members, questions here? My question for you, Robert, is, you know, you refer to this as a monster house. Are the variances sought in this application creating that quality about the house that you construe as being a monster house, or is it already a monster house in your view?
No, the original house was not. Was regarded in the neighborhood as a great example of a modest scale arts and crafts house. It's a shingle style house, and everybody recognized it as a very unique place. This addition on the back is a large box with a crudely crafted roof extension to the original roof of the house. And I think it's this roof that causes a lot of problems for people here. It's penetrated by these skylights and then looks a bit like a fortification. The reality is she could have put a simple hip roof on that addition, and I don't think anybody would have any issues with that. But she chose to extend the roof, the original roof of the house, to the back. And the top of this roof is basically, it's a large flat roof. And
Thank you very much.
completely inconsistent with the architecture you see around the neighborhood.
Thank you. Okay, let's go to the next speaker. We have one more or two more now, moderator? Two more.
Hi, Gerard, you've been unmuted.
Hi, yeah, I live at 55 Radford. I didn't submit a letter, but I did decide to, after reading some of the other letters, to call in, and I have probably two simple points. You know, one was about the tree. I'm kitty corner, so the corner of my lot is onto the corner of their lot. And it is the pine tree is a big issue for me because it actually does block most of the new big house. And so it was good to hear that the intention is to maintain that tree because it is an enormous tree that provides great cover for kind of all of the houses. I don't know if there's a possibility of mentioning that in the minutes that tree will stay. I know there are rules about taking trees down, but that would be one point I would make. The second is, you know, I understand the comments that have been made, and I agree with the prior speaker that it really is like it's described as a 2-story addition, but it was built as a 3-story addition. And I don't want to say that my new neighbors kind of did that on purpose, but it does seem that, you know, it was built so that you could make the 3rd floor space that was usable. And now, after it's built, we're coming back to the Committee of Adjustment to have this discussion. It's not clear to me why that discussion wasn't held at the start of that. And I would ask the committee, I don't know if this sort of situation has arisen in the past, because you know, I would say actually that the house, the 2nd story, the addition has been done well. It's brick. I think that's nice and it is consistent with the neighborhood. But as the prior speaker said, that, you know, that large roof really does stand out, and it stands out in a way that suggests it was always the intention. As I said, I'm not trying to say that the people did this on purpose, but it kind of suggests it was always done with the idea of making it into usable space. And so the original January 2022, you know, should have been the time when we had this discussion about 70%, 72% as opposed to 58%. And so not sure, some of the other speakers have said that there's anything that can really be done about that. But I do think that, you know, it's odd the way in which this has happened, and I would love the committee to comment on that. I don't have a lot of comments about the setback because it's not on my corner of the lot, but I would say I understand the concerns of the other neighbors around that. Thank you for the opportunity to speak.
Thank you very much. Okay, Mr. Salomon.
Yeah, I have a question for the speaker. So it appears that the 2-story addition and the roof did not require variances when it was built. So now, what is the impact of converting the roof into livable space?
But I guess that's my question. It does seem a bit disingenuous to now come and say, and you know, I mean, this is maybe a legal question, I'm not a lawyer. It does seem a bit disingenuous because the way it was built, it kind of looks, you know, I can see it out of my bedroom window. It looks like it was always built so that would be space as the prior.
What's the impact of it? The question is, what is the impact of the way it's been done? The impact on you as a neighbor is what?
Oh, it's just the large size. You know, as the prior speaker said, if they had built a more sloping roof, then I think it would be less you know, I hate to say it, but in your face, right? Like it's a big, to me, that's one of the big reasons as well why I think the pine tree is so important, because it actually blocks a lot of the house, which is significantly bigger than other houses in the neighborhood. I also have a 50-foot lot, and we gutted our house when we moved in 10, 12 years ago, and we did not get a variance because we didn't need it.
Okay.
And kind of kept it in the same character that we had it. This is, I think, less in character with the rest of the neighborhood, particularly the roof. And,
thank you very much.
You know,
okay.
Okay.
Thank you. Let's go on to the final speaker standing by.
Hi, Linda. You've been unmuted.
Okay. Am I unmuted now?
Yes, you are, Linda. You're with us. Please state your full name.
Linda Rodegard, and I'm at 75 BOUSTEAD. I'm across, not quite directly across from 94. And I think what most people are indicating is that there has been, I wouldn't say zero consulting with the community, because apparently some consulting did take place yesterday, but people are objecting to the fact that many changes were made to the house that was supposed to have been kept intact because of its historical significance. And there wasn't any consultation generally with most people in the community. I think there was with one neighbor, but that was it. And so there's a sense that things happen without telling or even asking the neighbors what their feedback was, which is not a really pleasant introduction to new neighbors, but that can all change too. And then another concern is from a neighbor directly to the west, and that is there has been damage done to her property in terms of the landscaping, and she has spent the summer with this kind of damage to the property, and she doesn't speak good English. She doesn't have access to a computer. She wants to know when the damage to her property will be taken care of. Will it be before winter? Will it be on the other people's timetable? Will it in fact be done at all? And is that the kind of thing that this particular consulting can deal with, because she has been impacted greatly? So two comments. One, the lack of consultation, and two, for the neighbor directly to the west, there has been damage done. I can only call it damage. And when will that be taken care of for her?
Okay, thank you.
Because she doesn't have the ability to ask for it or to speak directly to people, she asked that I make that request.
Thank you. Okay. Just as a general comment to those that have spoken, the five of you who have spoken, the Committee of Adjustment is, our responsibility here is to deal with the minor variances that are being applied for today in this application. So there are 4 of them. Those are the things that we have the ability to look at, consider, and to refuse or to approve. But I've heard a number of, I've heard your concerns, but some of them lie outside of the actual 4 variances. The Committee of Adjustment, for example, is not vested with punitive powers or disciplinary powers. We are asked to examine applications for minor variances in relation to the 4 tests that we apply to each minor variance. Okay, and with respect, for example, to the construction damage that another neighbor has experienced, that is something that neighbor would have to take up directly with the owner of the property. Okay, then let's at this stage go back to the applicant. I'm going to ask the applicant to address the issues that have been raised by people, and we'll go back now with that opportunity to respond in rebuttal.
Thank you very much. I think I just want to start by saying that with respect to the roof line of the house, it was our intention to honor the existing style of roof that was at the back of the house before we started the renovation. So essentially, we just elongated the exact same roof line and brought it down in the exact same pitch and fashion that the existing house was. So I'm sorry that that was offensive to some people, but essentially we're honoring the existing architecture with that construction. I wanted to just comment on a few things. There were a couple of points made regarding landscaping, regarding lot size, just a couple of things off the top that were not accurate when stated. We don't, just to start, it's not a 50-foot lot, it is 44. Second point was there was something mentioned in terms of the square footage. We were at 39.2% and added 32%. So it has not doubled in size. That is not an accurate fact with the construction. The third story, there was also questions pertaining to the third story being something that it seemed like was contrived from the beginning. I assure you that it wasn't. This is something that we saw that we were just said, you know, the space is here. Let's access it if we can. And that's why we went back to committee for this request. It absolutely could have been something that was added later. I'm a big builder in the community. I do a lot of work, and it was important to me that I honor the process and come back and make sure that I'm doing this right and that we are asking for these variances on paper as we are supposed to do and comply with everything as far as the City of Toronto goes. That's the utmost importance to me, and that's why these have come up. Regarding to just 55 Radford, Gerald, the tree, thank you for saying that. That tree is very important to us. Absolutely, it will remain. It will be protected. It's gorgeous. So just to address that, thank you for that comment. Also, yes, new fence is being put around the entire property. That has been confirmed. That was something that everybody was asking about. The pool shed itself, it is a pool shed to house mechanical. It looks like there's two sections because I think it's 60% of it is housing mechanical equipment and the other half will be storage. And it's not even half, it's 40%, I think is storage, right? Yeah, 40% storage. Drainage. There's absolutely nothing to worry about in terms of drainage. My builders are exceptional. It's Irwin Allen. I've worked with them on properties all over Toronto. I've never had a drainage concern. Please don't worry about that. Leave that to us. I assure you that is not a concern. Gardens and landscaping. There was one statement regarding that. We're 63.1% of the rear yard is soft landscaping. It is not hardscaping. The pool counts as soft permeable landscaping. So we have met all requirements in terms of the landscaping. Maddie, am I missing anything else here? New fence. I think I've addressed everything. That being said, to everybody on this call, please reach out to me if you have questions. I'd love to help answer anything I can. My phone number is on all of the documentation that I provided. So is my email address. Please reach out.
Okay, thank you. Panel members, questions for the owner. Go ahead, Mr. Salomon.
The question about variance number 1. So I just want to clarify what exactly is triggering the variance 1, the increase in FSI?
We were just asking to complete the attic, like to actually finish the attic space. So I would like to put hardwood down and have it as livable space because right now it's not. It's already built and it's there because we complied with everything. But I just wanted to have it as livable space and add a staircase in order to access it.
And so then it's strictly the conversion of the attic to livable space that is creating the increase in the FSI.
Correct.
Thank you.
Any further questions, panel? In that case, I think we are at the stage now that we can take this application into committee for a motion. If there are any comments first, fine. Ms. Chan, yes, what would you like to say?
Yes, I think that maybe some of the opposition, they mistaken or understanding what they're doing. In fact, what they're doing is they have built this addition with permits, and they just want to convert the existing attic into habitable space, and that triggers the floor space index. And I mean, and also they have also deleted, I think, the setback variance of the shed anyway. So I think that this is very minor application, and I don't have any issue with this.
Thank you. Other comments, anyone? Anyone ready with the motion? Mr. Salomon?
Yeah, I would agree with those comments. I'm going to move a motion to approve the revised variances and with no conditions. And so I believe the variances are, is it variance 3 or 2 that's being deleted?
I'm confused with that too. That's why I didn't
Through
specify
you,
which one
Mr.
being
Chair.
deleted.
Through you, Mr. Chair, variance number 2 has been removed. And for variance number 4, it's the first line regarding the north setback has been removed.
That's the line, Mr. Salomon, that reads point, will be located point 0.02 from the rear north lot line. That's gone.
Okay, and so I would move approval with no conditions.
There we are. Of the revised application. That is seconded by Ms. Chen. So moved and seconded to approve the revised application without condition. Those in favor, please, show of hands. And that is a unanimous vote to carry the motion and to approve the application. Thank you. With that, we complete the segment of applications. So we're a little bit behind now on starting the 3:30 session with number 33 application. However, the panel has been a little more than a couple of hours at this now, so we are going to recess for 10 minutes so that the panel can refresh, and we shall resume at 4:22 with number 33 on the agenda. Thank you very much. We're now in recess for 10 minutes. We resume. And we resume with application number 33, 250 Markham Street. On 250 Markham, committee has before it applicant's materials, plus a revised site plan and other plans received 19 September. There are a number of previous Committee of Adjustment decisions affecting the properties at 539 Crawford and 408 Markham. And there are presentation materials from the agent from September. We have a staff report from Community Planning, dated September 15. And I'll just check with you, moderator, as we begin. Do we have one person standing by in opposition to speak?
Through you, Mr. Chair, the speaker in opposition was online earlier. I'm trying to get a hold of him now.
You're trying, okay. Okay. I'll give you a moment to see if you can do that, because that'll... Okay, well, we'll go ahead then and assume that you can perhaps get them. Okay, then, we'll have the agent join us, please.
Can you hear me?
Hear you well. Please state your name.
Thank you. Good afternoon. This is Mohammed Firouzi from LHW Engineering, located at 2347 Kennedy Road, Toronto. We are the agent and designer of the 250 Markham Street. We have submitted materials, as you said. So if I need to have to go with the presentation, just please let me know. I can go with it, or I'm here for any other questions you have. Thank you.
Thank you very much. I'm just going to check once again with the moderator to see if we have one person standing by, a registered agent who is we're just seeing if we can make contact with them. So let's just check with the moderator.
I'm so sorry. If you have another agent, she may be my colleague, because
No. This is a person registered to speak in opposition.
Oh, okay. Thank you.
I have a quick question. Yeah.
Let's do questions then. Okay, questions for the applicant panel. Go ahead.
Since we're waiting, I thought maybe I can ask a quick question. You have submitted revised site plan. Can you tell us what's the difference between the revised site plan from the original site plan?
Actually, the revised and the previous site plan, they have kind of almost nothing to change. The point is we have added a rooftop green, kind of green rooftop, let's say. So because of that, we just updated all of our drawings. That's why you see that just the site plan. Plus, in the table we provide the information. So when we change the amount of soft landscaping, this one, the site statistics would be changed. So like visually in our drawing on site plan, you would see no changes. But when you go to the addition, you will see those hatches at the very end of the addition, which is almost 4 meters. That 4 meters is the new green rooftop we added to meet the city planner advice of meeting the minimum requirements of the soft landscaping. But anyway, we are a bit more than the minimum for the soft landscape. Yeah.
Well,
are you revising variance number 3?
Yes.
Does variance number 3 change? You're showing 10%.
Actually, when I'm sorry, if you go, let me just, yeah, here, if you saw our last submission, you'll see that we didn't have that rooftop, green rooftop. So without that green rooftop, we had 10% of the soft landscaping on the ground, which is almost 2 meter by 3 meter. So that is 10%. But by adding that green rooftop, which you can see it in 3D vision as well, we have added. So we just, yeah, if you go to presentation, yeah. No, we have some plans, I think.
Okay, I think I see where you're going, but here's the issue. Number 3 variance right now.
Yeah, here. Yeah. Okay.
Okay, so the green rooftop, I get it. The green rooftop mitigates to some degree, but green rooftops, as desirable as they can be, are not the same as soft landscaping. So your variance number 3 is very deficient. You're only at 10%, where 25% is required. That hasn't changed.
Actually, we have been communicated with the city planner, and they just ask us to either have a green rooftop. I have the email conversation with him. Like either we can have a green rooftop, and then there was another solution, but we picked the green rooftop, as you see in the planner report as well.
What was the other solution?
Yeah. Let me just bring it up.
Reduce the length of the proposal?
Yeah, I believe so, something, yeah.
Yeah. I mean, the two things, variance number 1 and variance number 3 are directly related. The fact that you have a very, very large depth of 25 meters is the reason why you have a deficient soft landscaping quotient at 10% when 25 is required. The two are directly related.
Yes. So, in fact, when we just changed the depth, so we couldn't meet the minimum soft landscaping. So, in order to provide the minimum soft landscaping, we just choose to have that green rooftop. Green, yeah. Green
Other
rooftop.
questions, panel
So,
member,
yeah.
for the applicant? Moderator, do we have the person on? We do. We do. Very good. Okay. So, panel members, I'm pleased to say we do have the registered speaker in opposition in touch now, and we're going to ask that, well, we'll ask that speaker to stand by. I'm going to give the applicant a chance. Applicant, anything else I'm going to give you a chance to make a brief presentation before we hear from the registered speaker in opposition. Go ahead.
Sorry, I missed you.
Okay.
I missed you.
Okay.
I missed your voice.
Here's what I want you to understand. We do have a speaker who's registered to speak in opposition, someone who wants to talk to this. I'm going to give you a chance to make a brief presentation about your application. It'll be 5 minutes maximum. So go ahead and tell us about your application, please.
Sure. So basically, our application is about to having an addition, like a rear addition to an existing building, a 2-story rear addition to an existing building. And the main intention of the owner is to have more rooms as their family is growing, and so they need more rooms for their kids. So it's a single family dwelling unit they are going to have, right? And the owner would like to have more space for their children and live, and their family growing larger, and like by utilizing some of the space to the rear yard of the existing house, they can have 2 more bedrooms to accommodate the new family members. Plus, with these 2-story addition, so I think there is no negative effect on the adjacent properties or the neighbors. So the approximate 2 meters by 3.3 meters is left for the design purpose of the rural landscaping. So this construction brings a huge value to the family, so they can live like in a better space. The point here is the depth this addition is going is not passing any maximum depth of other neighbors they might have. In our presentation, you can see that we just marked the line of our addition, which it's not passing others. So there is a line in the street. So you just can see that we are not going further other long residential buildings that are existing in the street. If you can find it, I can. Yeah, you can see them here. Yeah. This is 250, and you'll see the others, right? So exactly. And on the next page, we have draw a line, like a dash line on the next page of this presentation. Yes, exactly. So this is 250, and you'll see others that they have some kind of additions before or whatever, and we are not going to pass them at any chances. And as I said, like for the purpose of the soft landscaping, as we have been communicated with the planner, we have decided to have minimum 50% of the roof of the addition for the soft landscaping, and then meets the requirements they needed.
Very good, thank you. All right, so this photograph, aerial photograph, is helpful. Let's go now to the speaker standing by to speak.
Can you hear me?
We do hear you. State your name, please.
Thank you. Good afternoon, everyone. My name is Peter Pashari. I live at 252 Markham Street. First of all, I take exception to the fact that they're saying it's a single-family residence with a growing family. Currently, there are no kids on the premises, so I take considerable issue with that statement. I don't think it's a minor variance. The depth that they're talking about is an increase of 50%. It's almost an 80% increase in the floor space. I have a very prolific garden. So the home is east-west, and it gets morning and afternoon sun. And we're talking about a massive structure that will, in essence, put that garden under shade conditions throughout the day. So I think that's a really big problem. Flooding is definitely an issue. This is the first I'm hearing about the green roof. But if we get a good rainfall now, there's severe flooding. And my residence, basically, the back is all landscaping, and things flood considerably. So I think their soft landscaping is going to be a big, big issue. As far as the length of the homes on the street, a lot of those homes were built in the 1800s. So a lot of those structures, certainly the house at 254 Markham Street, that house has been in existence since early 1940s. So the fact that there's structures with the same depth doesn't really mean that they've been recent construction. So I think one of the biggest issues is that if we go outside, we're going to see this massive wall. So the openness of the sky, the openness of the backyard is going to be lost. So I think that's one of the major issues that we have with this addition. It is just way too big. So, and I think that's all I have to say. So,
okay, Peter.
Thank you very much.
Thank you very much. I have a question for you. Your address shows at 250 Markham. Do you live in this building?
252 Markham.
You're 252. Pardon me. Okay.
Yeah, it's the semi-detached that's attached to 250.
Okay, so that's just a typo here. So you're next door.
I'm right next door, yes, sir.
And will this be longer than your property, your house?
Oh, it's definitely going to be longer. So if you have their plans, you'll see where basically the roof of my shed, it's going to continue an extra.
Let's see if we can zoom in here. Can we zoom in on this photograph? This aerial photograph? How much longer is you're 252? Okay.
So the existing structure at the back, the one-room addition, that's basically an illegal addition. That was put in when I first bought the property. They had an addition that extended to what they're proposing now, except it was just a single story at that point, which the city denied after a while, and they cut it back to just one room. But it's a derelict room, so that room isn't being used.
Okay.
So all of that at the back is an illegal structure that shouldn't be there.
Peter, I'm looking at this aerial photograph, and I see some houses are shorter, and there's a couple that may be longer. Are those longer ones, or are those recent additions? It's in the last 20 years?
That 254? No, that's been in existence since the 1940s or earlier.
Okay.
And the one that is just to the south of them, that property used to be the local grocery store. So that's why they've gone that far as depth goes. So it's a long property because that used to be a grocery store.
So what's going to happen to you is the impact on this, on your property, if this was approved, would be what? In the if you were standing in your backyard, if you're standing in your backyard, what would the impact on you be?
Well, for one thing, it's going to darken the backyard. So my garden won't grow as well as it is currently growing. And all I'm going to see is this big, massive wall.
Okay. Ms. Chan, go ahead. Ms. Chang?
Just a quick question to this speaker. You mentioned it's 254, they have extension. Is that a one-story or two-story extension? Can you tell us?
Which addition are you talking about?
254.
Yeah, it's on the, yes, 554. Yeah. So
yeah.
you can see there's the extension.
254 is actually my mother's house, and that extension has been in place since the early 1940s.
One or two story?
It's one story.
One story, okay.
Yeah, that's my question. Thank you.
One story is being generous. That's full construction, so, okay.
That's important, yeah. Thank you.
Okay.
Yeah.
Any other questions for this speaker panel? Okay. Let's then return to the agent for an opportunity to speak in rebuttal.
Thank you. So if I'm going like kind of one by one, for the green roof and the concern of the flooding or any water damages like that. So this is kind of like always makes sense concern. That's why we have the assembly of how you can build a garden roof or a green rooftop, which won't go to do any damage of like any damage of water related or frozen related or snow related, even in like kind of weight related. So we definitely follow them, like whatever code says, even more, or whatever protection it needed to have the protection of not being the cause of any damages. So definitely the building code would stop us before even we get approval on the layers and the assembly we are going to choose for the protection of any flood, water, or snow damages in terms of having any green roof. For the lights, I believe there is a misunderstanding here because the direction of the house is is kind of east to west. So I believe from the sun rising and sun setting, generally at half of the time we do not have the lights anyways. I can share my screen and show you the direction.
No.
Or yeah. So but by the way, if you go to the very first page of our presentation, we can see the north arrow. Yeah.
I'd rather you address the question of, I'd like to hear you address the question. Peter next door says when he's standing, or when he might be standing in the future in his backyard, he's going to see nothing but a massive two-story wall. Address that. Address that question.
Yeah, basically, like I believe, like couple of neighbors here, they might have this this situation, like basically, because a couple of these neighbors, they already built 1 or 2 story building additions, as we see here, and even if they are for like kind of past, or if they do the renovation, for sure they will keep it forever.
I'm talking about your renovation. I'm talking about your renovation. No, I'm talking about yours. You're next door to Peter. He says he's going to stand in his backyard and see a massive wall. Is that true or not?
So as we are going further, so basically they will see the wall. So what we can do is we can make the wall like somehow, it's not that ugly, but anyway, building and structure makes it visible. So we cannot do, like, we can do the construction, we can do it as the best way we can. We can do the cladding of it as the best we can. But let's say if I was the neighbor, so my neighbor would see that as well. So this situation in terms of the length of the house would may happen. Like, let's say not us, like if someone else says get this approval, the neighbors like get this. If the mass of the houses can be approved, so that like at the next stage, the 1 stories, the 2 stories.
I'll ask you to make your final comment now, please.
Yeah. So what I believe is, as this neighbor is having this line of the maximum depth, so if we can just have this, so everyone else can have this. I mean, as someone before us had this, so that would be something same to all of the neighbors, like equally. Yep, that is small. Thank you.
Your time is up. Thank you.
Thank you so much.
Are there any questions, panel, for the agent at this stage? In that case, we can take the application into committee. I'm going to ask staff to put up, there was another drawing that shows, it's a kind of a rendering of what this property would look like. There it is, yeah. If you'd blow that one up and leave it on the screen so we can see. Okay. Let's go into committee now and we'll go for some comments. Ms. Chan, go ahead.
Hey, I have real problem with the depth of this building. I think that by extending it so far, at the most, it can accommodate maybe a 1-story addition. And then the second floor probably should step back. And because if you look at the site plan, the proposal is almost going to eliminate the existence of a backyard. I do not think this is a good planning. I cannot support this because of the height and also the depth of the.
Thank you. Any other comments, panel members? Mr. Reed?
Yeah, I just want to echo what Yim said. I think this is a gross exaggeration, and I think it would be 25 feet of 2-story wall that would be facing the neighbors. And I think just because there's length that exists in the neighborhood, we didn't hear anything about there being 2-story length or 3 or 1. I think this is a real overdevelopment of the site that results in basically zero backyard and almost full coverage of the lot.
Thank you. Anyone ready with a motion on this one? I happen to agree with both of your thoughts. Ms. Chan?
Anyone wants to make comments?
Oh, you can make
Okay,
it.
I will propose to refuse this application, and because the variants are not minor.
Thank you. Is there a second to that motion? It is seconded, Mr. Reed. Moved and seconded to refuse. Those in favor, please, show of hands. That's a unanimous vote. To carry the motion, the application is thereby refused. And that moves the panel along to number 34. Three Babby Point Crescent. On this application we have before us, copy of materials submitted. We have correspondence from from City Planning, Heritage Planning section, and we have a staff report from the Heritage Planning, Archaeology, Heritage Planning, received 14 September. So, let's have the applicant join us.
Good afternoon, Mr. Chair. My name is Addison Milne Price, planner at Design Plan Services, 900 The East Mall, and I'm the agent of this application.
Very good. Thank you very much. I'm just going to check with colleagues here to see if they'd like you to make a presentation or whether they have questions instead. Any questions for this applicant? Mr. Salomon, go ahead.
Yeah, my question was dealing with the eaves, the roof of the eaves of the proposed ancillary structure, and they're going to go right to the lot line on one side, and I'm wondering why can't they be set back so that any water runoff doesn't run off onto the adjacent property?
Through you, Mr. Chair, the new ancillary building will be constructed on top of the existing foundation of the rear detached garage. So as a result, the walls will be in the exact same position, and the eaves will be necessarily in that location.
Okay, thank you.
But is the accessory structure exactly the same size as the existing garage foundation?
Yes, through to you, Mr. Chair.
Yes.
The accessory structure is the exact same size.
Okay, thank you.
Further questions? Hearing none, let's take this application into committee for a motion. Mr. Reed.
Thanks, Chair. I think what's being proposed is very reasonable. It's nearly a mimic of what's there now, and I think the impacts of that will be very minor. So I move approval of the application subject.
Is there a second to that motion? It is seconded, Mr. Salomon. Moved and seconded to approve. All in favor, please show hands. And that vote is unanimous. It carries the motion to approve the application. Number 35 is 1181 Queen Street West. Here we are looking at submitted materials, cover letter from the agent, June the 22nd, and there is a site-specific bylaw to amend the former City of Toronto zoning bylaw with respect to lands known municipally as 1181 and 1187 Queen West. Okay, we'll ask the agent to join us, please.
Good afternoon, Mr. Chair. It's Mr. Bronskill, first initial D for David, here on behalf of the applicant. I hope my audio is coming through okay.
Very clearly. Thank you. Okay. Panel members, any questions here for the agent? Apparently not. Okay, in that case, we can take the application into committee for a motion. Ms. Chan, go ahead.
I think this is a very straightforward application, and I do not see any negative impact by the change. So I think I can move to approve with no conditions.
Second to that motion? It is seconded, Mr. Reed. So moved and seconded to approve. All in favor, please show hands. Motion carried, and the application is approved.
Thank you, Mr. Chair.
Thank you. Number 36 is 41 West Lynn Avenue. On this application, we have submitted materials. We have a staff report from Urban Forestry. In support, there are 2 form letters from 39 and 43 West Lynn received on September 7th. Okay. And we shall ask the agent to join us, please.
Mr. Chair, members of committee, my name is David Smith. I'm here representing the homeowners at 41 Westland Avenue. My address is 401 Craven Road here in Toronto, Ontario.
Thank you very much. Questions, panel? Hearing no questions, we can take the application into committee for a motion. Mr. Salomon, go ahead.
Yeah, I think that the variance is minor in nature, and I would move approval with condition urban forestry number 2.
Thank you very much. That is seconded, Mr. Reed. Moved and seconded to approve, subject to forestry. All in favor? Show of hands. Motion carried. Application approved. Number 37, 480 Front Street West. Here we are looking at those materials that were submitted with the application. Cover letter from the agent, July 19. A previous decision by the Committee of Adjustment that affects the property, 2020. And a copy of the site plan agreement received in August. So we'll ask the agent to join us, please.
Hello, Mr. Chair and committee. My name is Samantha Bites, and I am a development coordinator with RioCan Management, Inc., and I'll be speaking on behalf of owner Rad Front Wellington Nominee, Inc.
Good afternoon. Panel members, questions, comments? Okay. Samantha, I did want to say that I think it's good that you're bringing bowling back to downtown Toronto because I don't think there is any bowling down there right now, and around other parts of the city, you know, some bowling alleys have been lost recently to development. So good to see it coming back into central Toronto potentially. So panel members, if there are no questions, let's take the application into committee for a motion, please. Ms. Chan, go ahead.
I have no issues, and I agree with you. I think it's a good idea to have bowling alley than maybe no physical exercise. So, okay, I can move for approval with no conditions.
Thank you. Seconded by Mr. Reed. Moved and seconded to approve. Those in favor, please, show of hands. Motion carried. The application is approved. Number 38 is 65 Dundas Street. East. Here we have application materials, cover letter agent, August. Presentation materials agent, September. We have commenting reports from City Planning, Transportation Services. And we have one piece of correspondence in interest or concern from Pauline Larson of the Downtown Young Business Improvement Area, received September 12. Okay. So I'll just ask you, moderator, here I see a number of persons observing and standing by to answer questions if necessary. Is there anyone in opposition here?
Through you, Mr. Chair, there's no opposition.
No opposition, okay. Okay, then let's have the agent join us, please.
Afternoon, everyone. My name is Miles Weeks. I'm a senior planner with FO10 Consultants, representing the applicant on this project.
Good afternoon to you. Okay. Panel members, any questions? Ms. Chan, proceed.
The project mentions is going to be affordable housing. Do you have to enter a formal commitment or agreement with the city that this will be affordable in the future?
Through you, Mr. Chair, this is a city project. It is being run by the city, so I think it's safe to say that they're committed to it. However, I do have colleagues from the City of Toronto available to speak to it if you'd like more details.
Because on our agenda, it did not mention that the city has ownership of this property. That's why I asked the question.
So I would just defer to either Matt, Ryan, or Arnold if you're on the phone. If you could just maybe provide a few more details for the committee on the affordable housing component.
Hello.
Miles for passing the question. Yeah, through the chair, the city acquired the property earlier this summer, earlier in September actually. So it is a city-owned property, and the residential units being created there will be affordable for the full duration of city ownership. This project has been funded by the federal government through the Rapid Housing Initiative, which has also affordability requirements on the city at this project.
Very interesting. Thank you. Panel members, if there are no further questions, we can take this one into committee for a motion. Mr. Reid, please.
Thanks, Chair. This is an admirable and necessary project, and I think that the variances required to make it happen are minor. I think this is really just using the existing structure and retrofitting it slightly to accommodate smallish affordable units. So I can see no negative impact in granting these variances and move approval with no conditions.
Thank you. That is seconded by Ms. Chan. Moved and seconded to approve without condition. Those in favor, please show of hands. And that is a unanimous vote. To carry the motion, the application is so approved. On number 39, there is a request to defer. This is application this is the application for 789 Euclid Avenue, which involves a severance application plus a pair of minor variance applications. So let's ask the agent to join us, please.
My agent, Harold Maddy, is in an OLT session right now.
Who are you, please?
Sorry, my name is Breck McFarlane. I'm the owner of the property.
That's fine, okay. You can-
My agent, Harold Maddy, planner, is in an OLT hearing that's extending all week right now. So he's not able to be here.
We do understand, but we'll ask you as the owner, can you tell us the rationale for behind your request to defer?
Simple. During the notice period, a neighbor scrutinized the, well, I received a revised zoning notice during the period for the infill dwelling. So the proper notice wasn't given. So basically Stanley said, it looks like you'll have to defer. So that's the scenario.
There we are, okay.
But here's a funny thing. There's a lot of opposition to the project, you might have noticed, which has a lot of letters which are all seem to assume that their existing homes match the zoning bylaw when they're up to 3 times the density of the allowable.
Wait a second.
But what I want to say is that I actually, another reason why it would be good to defer, in addition to the late notice from the city notice, is that I've actually come up with a different solution that is more minor, lower, and doesn't have a basement and doesn't require consent, or not consent, but a conveyance. So I think all parties would be served by deferring. And I actually sent that to you via one of my PDFs that Stanley would have received this morning.
Okay, Mr. McFarland, that's very valuable information, actually. So, just to give you a sense here of what happens next, obviously it is the committee itself which will decide whether to defer or to go ahead and hear the application. Now, the fact that notice was improper is pretty convincing. So, but what I want to do though is to simply check with those that are standing by, because some of them have been patiently registered and standing by, I am guessing, for a number of hours conceivably. So we're going to do that first, then we'll come back to the panel for a decision on the deferral request. Okay. Stanley, could I have the first person standing by, please?
Hi, Stefan, you've been unmuted.
Hi there, my name is Stéphane LeBlanc. I am at 49 Palmerston Square, so I'm 2-3 doors down there on the south corner. And ultimately, I'm in opposition of these variances because...
Okay, Stefan, just pardon me for interrupting you. At this point, I'm coming to each of you for a very specific reason, and I'm not even going to get into the rationale for refusals or approvals. What I want to ask you is there's now, it turns out that the application was not posted early enough to comply with the regulations. And also we have the owner saying that he'd like to revise the application, making it less onerous. So how would you feel about, if we didn't go ahead and hear this today, would you be okay with that if we deferred it and let this process work itself out?
Yes, and I would love to see what the new proposition is.
Very good. That's all I really have for you. I'm going to go on now to the next person who's standing by, and thank you for your having stood by to speak. Next person, please. And again, then with the next person, I think it's Robin.
Hi. Okay. Hi, yeah, I'm at 793 Euclid. I'm a couple of doors up from Breck. I'm fine with letting the process go forward, but my question now is, what about 789? Because he has asked for particular things with the existing structure, and are we leaving that for later, or is that something that we deal with now?
Well, we are dealing with 789. Now, that 789 is this application. As far as we're concerned, we're dealing with 789.
Yeah, but he was we were talking about building a laneway house, about severing the lot, and also dealing with the apartments in the existing structure. So
I
there's
don't-
three
okay.
different aspects.
Okay, so I do not, Robin, want to get into the detail of the applications. We have a situation in which the applicant knows that he was late posting the notice. So, plus he has volunteered that he'd like to revise the application and make it less onerous. So I'm just
Okay, no, I get it.
getting your general thought on that. We have to see what comes out of it at the end, but the fact that it was posted late is a big problem. So,
Okay, good.
yeah. Okay, so thank you for that. Let's go on
Okay.
to the final person standing by.
Hello?
Hello. Is that Joan?
Yes, it is.
Joan, here's my only question for you. I don't know how long you've been waiting. How long have you been waiting?
Since before 4:30.
Oh, okay. All right. So not a deadly long time. Thank you. Thank you for that too. So my question to you is this: would you be at ease if we were to defer this application? It turns out that the notice wasn't posted early enough at the site. Beyond that, the applicant has said he's ready to revise the application to make it less of a problem to neighbors. Is that okay with you to go ahead in that direction?
It's okay to defer.
Thank you. Okay. So panel members, there we go. I come back to the panel now for a motion on this one with respect to the deferral request. Ms. Chan, go ahead.
Yes, I will add another reason for the deferral is also the applicant will consult the neighbors for the new revised plans.
Okay. That's your motion? You're moving to defer. Okay, is there a second to that motion? It is seconded. Mr. Reed. Moved and seconded to defer. Those in favor, please show hands. Unanimous vote to carry the motion. Application is deferred. Okay. And that takes us along to number 40, 76 Poplar Plains Crescent. On this application, we have before us submitted materials, cover letter from the agent, a TLAB decision which affected the property, arborist report, presentation materials received September. We have comment from community planning of city planning. There is a staff report from engineering and construction. There is a letter from Councillor Matlow. There is support and opposition correspondence. Support, 71, 77, 75 Poplar Plains, Crescent. Opposition, from James Appleyard, Joseph Zankowitz, Stephen Fried, Sonia Luchetta, Tony Cohen, Arnold Englander, Teresa Brzezowski, Mary Englander, and Moira Cohen. No address provided. Okay then. Moderator, could you give me a sense of how many speakers we have standing by to speak?
Through you, Mr. Chair, we have 4 speakers in opposition.
Thank you very much. Okay. Let's have the agent join us, please.
Hello, Mr. Chairman, Franco Romano here on behalf of the owner, 2095 Autumn Breeze Port Credit.
Very good. You have 5 minutes to present your application. Go ahead.
Thank you, sir. What's before us on the panel here right now is a on the screen is a site plan drawing that shows 2 dwellings. So those 2 dwellings are authorized by way of the TLAB decision, and there's no change or alteration to what's occurring there. So what's in front of this panel today is simply the severance. And if we can go to my presentation material, you will see that the severance that's being proposed is one that is approved by the Toronto Local Appeal Body. And that approval came as a result of a significant and detailed collaboration and an extensive mediation and settlement that occurred with the assistance of the TLAB. And there were about 3 different TLAB members that participated. So if we go to actually slide 2, please, you'll see that the property is located on the north side of Poplar Plains Crescent, first block west of Avenue Road. The immediate context is a mixed lot size character, and you'll see that 84.3% of the lots on Poplar Plains are smaller than 460 square meters, and they range in lot frontage from 7.9 meters to 26.5 meters. The existing lot is one of the largest lots in the area. The site is the largest lot frontage, being 28.21 meters along Poplar Plains Crescent. Proposal is to obtain consent approval to subdivide the lot down the middle and create 2 lots. And you'll see that on the top on slide number 1. So there's some reference to, on slide number 1, you'll see the severance. First page, yes, thank you. So what had occurred in 2018 was a severance that is different than this. And through the TLAB mediation and settlement with a number of the persons that have written in, the severance was modified. So then the 2 lots were essentially creating 2 equal size lots. They're a little different because it is skewed. But part 1 is 14.61 meters. And part 2 is 13.6 meters in frontage. Both of those comply with the bylaw, and they are anywhere from 68 to 70. The lots in the immediate context are smaller than what is being proposed. The lots, 68 to 74% of the lots on Poplar Plains are smaller than what is being proposed. So the severance here is identical to the severance that was submitted to and approved by the TLAB and all parties and participants that signed a settlement agreement. The reason why the severance is now before the panel is because the 1-year time frame to satisfy all consent conditions lapsed on June 1st, 2021. Everyone was notified of that and was discussed through meetings in March of 2022, and the application was for severance to the Committee of Adjustment was filed in May of 2022. In August of 2022, I did email everyone to advise them of this date, today's date, after the city confirmed today's date, and I've received no responses or questions or requests for any additional information. The severance before you today, Mr. Chairman, is identical to that was approved by the TLAB and approved and signed off by all parties and participants that have signed that or I guess is listed on the letter, but that is not signed by persons. And they've been provided that both in November of 2019, and I understand that most recently, earlier this month, they did find that document as well. So subject to any questions, I submit that what is being proposed here is satisfies all of the consent criteria. The planning department has reviewed it and they have no concerns or objections. Engineering Construction Services has 1 condition of approval relating to municipal numbering because they've already reviewed the R plan back in 2020, which is dated in 2020, and they're satisfied that it could be registered. Subject to any questions, I submit that the application should be approved.
Thank you very much. We do have people standing by to speak in opposition. So let me ask you, just before we go to them, one question, and that is, after all the work that you went to, or that was gone to get the TLAB okay, Well, why did the application, why was it allowed to lapse?
Wasn't that it was allowed to lapse, sir. I think what happened is you'll see that the TLAB decision, which is on the record, is dated June 2nd, 2020. And the conditions of consent approval includes the fact that a certificate of official must be issued within one year. So that would have been in the height of COVID, but also what happened with the landowners is that they had family medical and bereavement matters that took them out of country and had their attention elsewhere. So they could not satisfy all of the conditions of consent. And you'll find those as we're scrolling down on page 7 of the decision. I'm not sure that that's numbered actually.
You've answered my question. Now I get it. Other things came up that drew their attention. Okay. Very good. Any other questions, panel, at this stage for the agent? Okay. Let's go then to the first of the registered speakers.
Hi, William. You've been unmuted.
Can you hear me?
We hear you clearly. State your name, please.
My name is William Gragnoli. I live at 74 Poplar Plains Crescent. I'm one of the adjacent neighbors. My understanding, we've, as a committee for the neighborhood in addressing this issue, we nominated Arnold Englander to kind of set the stage for our discussion. I'd like to defer that to him since he's been prepped to deal with this initially. I'm hoping that you would come back to me later, but that's my recommendation now.
Okay, he's standing by, I understand, to speak. So if I understand you correctly, you're ready to pass up your opportunity to speak and for us to go to Arnold Englander next.
Only if I get an opportunity later, Chairman.
You'd like to speak later?
Yes.
I don't see a problem with that. Okay, let's go to Mr. Englander first.
Oh, can you hear me?
We do hear you. Please state your name.
My name is Arnold Englander. I live at 57 Poplar Plains Road, which, as you can see, is a north-south street, whereas Poplar Plains Crescent runs into Poplar Plains Road. I've been asked to speak on behalf of the neighbors who have filed the opposition to proceeding. But the background, of course, of this matter was correctly stated by Mr. Romano, namely that this goes back a number of years, back to, in fact, I've seen documents dated the year 2017, and there have been discussions between the applicants and members of the neighborhood who have submitted this opposition. In fact, we have requested a deferral, and the reasons were set out in a email from Mr. Gragnoli to Wilser Kennel, dated September 19, 2022. And our request states a number of reasons. I'm wondering if the members of the committee have in front of them the September 19 email from Mr. Gragnoli.
Here's my question to you, Mr. Englander. You're using up your 5 minutes now, and you're spokesman for the group. I want to suggest to you that you have a remaining 3 minutes now to go. I want to suggest that you use that time to give us the flavor of how you're concerned about the impact of this proposal.
Well, we are asking for a deferral for the reasons set forth in the email of September 19. And primarily as well, we received a commitment. One of the members of our group received a commitment from the applicant, Yuri Kolodov, with respect to this property. And we believe that having regard to the fact that the applicant, Mr. Kolodov, is not in Canada at the present time, although I assume that he is watching the proceedings, we want him to fulfill his commitment. And for that purpose, we need some time to draft the commitment that he provided by email on September 14 to one of our members.
So,
Hence, that document needs to be signed or created initially and signed by the parties to fulfill the commitment. And the commitment follows what has been referred to by Mr. Romano and referred to in the TLAB documentation as the settlement agreement. And that is the prime reason why we require an adjournment, which is a deferral rather.
this is to allow time for you to do, to submit. Okay, anyway, you've described it. Okay. You still have a minute to go. How do you want to use that minute?
Well, it's very important to us to obtain this deferral, since in fact, from a point of view as well of making submissions on the substance of the matter, it's, as I said, it's been difficult to deal with Mr. Kolodov, who's not in Canada. And we received, most of us received the notification in the second week of September. So 14 days, with all due respect, is not sufficient time for us to prepare appropriate documents. But what we are driving at is the need to have the opportunity to negotiate an amendment to the settlement documents that is in fulfillment of the commitment made by the applicant, Mr. Kolodov,
Okay.
to one of the parties.
Okay, your time is now up. Thank you very much. And we'll go on now to the next speaker.
I do have a question.
Go ahead.
So how does the settlement agreement that you're referring to, which we don't know anything about, how does it affect the proposed severance?
Yes, it would affect it in that it would ensure for the parties who are the neighbors that the procedure will not be further amended.
The new owner.
They have, I don't have to tell you, anybody can come back to the Committee of Adjustments and make further requests. And as you know, the variances were authorized by TLAB. In addition, those variances were in conjunction with the severance request. The position of the neighbors is that we don't wish any further attempt to vary what has already been ordered, and we don't wish any attempt to further sever the property
Okay.
over and above what's requested.
I have a question, Mr. Englander. Okay, so so you were satisfied with the result from TLAB. Is it your impression that the present application does alter that?
The substance of the present application, of course, simply follows TLAB, so there is no deviation therefrom.
There is no deviation, but is it true that you were satisfied with the TLAB decision?
Well, we signed minutes that we had minutes of settlement that led to TLAB doing so.
Okay.
And we were, of course, satisfied with that. But since then, we do have concerns as to what may happen with respect to this application.
Thank you very much. I'm going to go on
may
now to the,
further
excuse me, I'm going on now to the next speaker. And let's go to the next speaker. And who is that moderator?
Hi, Stephen. You've been unmuted, and you may turn on your video.
Turn on my video. Here, start video.
Correct.
Okay. Hi. A few things. The neighbors never really were satisfied with the process. And in fact, the initial application to the Committee of Adjustments was soundly rejected by the Committee of Adjustments. The owner then took it to TLAB, and that's their right. And it's unfortunate that TLAB overrides or has the power to override the Committee of Adjustments. We did come and hammer out an agreement, but no one was really happy with it. It was for being at TLAB, and we really had no choice or to be taken over by the TLAB to make the decision. But the real issue is these houses are massive. They're going to totally distort the character of the street at that level, but specifically to the bylaws. And what we haven't had a clear answer, there's already flooding that goes on in the adjacent homes due to the ravine and the nature of the position of the homes and the natural geology. These homes are going to destroy virtually all the trees, all the shrubbery, and they're going to be built essentially into the back of the ravine. And we're quite worried, and I live across the street, but the neighbors are quite worried about future flooding and what's going to happen based on the size of the homes. Our recommendation is, and it's a beautiful property and there's a beautiful home on it, either to renovate the home or to rebuild the home, but to put in two massive homes is not our desire. And the second point, they want to put a driveway encompassing the entire surface of the two properties. Already parking has become very restricted. We used to have parking on both sides of the street. It's been eliminated on the south side of the street a few years ago, and there are very few spots to park. This is just going to make a congestion in our neighborhood even greater. So we would like the Committee of Adjustments to weigh those two big issues, and also to consider that we want to work with the Committee of Adjustments, and our preference was not to work with TLAB.
Okay, thank you very much. I have a question for you, and what you said is helpful. Now I understand that your sense of the impact of these houses will be as you've described. So my question to you is, the panel has sort of three choices here. We can approve this severance and the related minor variances. We can refuse them, or we can defer them. But this talk of deferral, is that your preference, or would you rather see a refusal?
Obviously, my preference is a refusal, but if in the wisdom of the committee that you wish to have further discussions with Mr. Kolodoff, who, is out of the country, it's very, very hard to work with him when apparently emails were sent in the last 2-3 days. He's not answering to them. So in the spirit of trying to solve this, and I think that's why we're all here, we're up against a wall.
Okay. Panel members, questions for this speaker? No. Okay. Thank you very much for your submission. Let's go on to the
Thank
next
you.
speaker, please.
Callback number, press 1. To replay your message, press 3.
Through you, Mr. Chair, I've tried to contact the last speaker and was unsuccessful.
Thanks, Valerie. Let's go back then to William Gragnoli. We'll go back to William now, who wanted a chance to speak a little later.
Can I be heard?
Hello, is that William?
This is he.
There you are, William, and now it is your opportunity. Please, go ahead.
Thank you very much, Mr. Chairman, and thank you as well, fellow committee members. Just a couple of things. I think our major focus today is hoping that the Committee of Adjustments, given the documentation both from the neighbors and the councillor, that they would consider a short rescheduling of the hearing for the reasons mentioned both in the documents from the neighbors and from the councillor's office. Having said that, regarding Mr. Franco, his comments, he is right regarding the previous Committee of Adjustments decisions and moving to the T-Lab, but I just want to remind the Committee of Adjustments that the initial severance application was in fact denied by the committee. I'm also a little bit concerned because I'm trying to understand, and again, I'm not a planner or a lawyer, the dimensions of the application or the public notice in terms of lot frontage for some reason doesn't comply with the site plans in the decision, and we need to better understand that because that really sets the stage in terms of where we're going on all this. I want to emphasize again that, you know, this has been going on since 2018, and it's been a tremendous amount of stress and anxiety, not only for the neighborhood, but also for the developer, who I might add has been very accommodating and helpful in terms of trying to come up with a platform that responds to the needs of our concern. So, but, you know, there are still concerns that we have, and I think we need a little bit of time to really address those in the best interest of all parties involved. And it goes beyond the variance, which I don't want to talk about because T-Lab has obviously approved that, but it's the foundation of the lot and the land of this community. This is not an ordinary lot. We're talking about
William,
a lot.
William, pardon me for interrupting you, but I just want to say what T-Lab approved, I understand, lapsed, regrettably. So what T-Lab approved has lapsed. So the Committee of Adjustment is back now. We're back in the driver's seat here. We're looking at these applications, and we have various ways forward on them: approve, refuse, or defer. But the T-Lab, unless I've got this wrong, the T-Lab approval no longer bears because it lapsed. So the Committee of Adjustment now has to run with this one. Is that? Do you understand what I'm saying?
I respect that, Mr. Chairman. I'm not talking about the T-Lab decision. I'm talking about the proposed plans.
Go ahead.
Okay, and I guess we've come a long way. We've made some inroads. I think we're almost there in dealing with this. But I think one of the concerns that really drags on with the community is the fact about the proposal, the impact and implications it may have. First of all, we're not talking about regular land. We're talking here about the Lake Iroquois shoreline that runs across the neighborhood and the lot. We're talking about the reverse ravines that will have a major impact on this recommendation for proposal for the double dwellings. I mean, the other thing is that I'm not sure if you're familiar with the neighborhood, but this has become, interesting enough, a sanctuary for a tremendous amount of variety of wildlife, both in general animals and birds and everything. And also, I think we need to remember and kind of respect the estates that started here, from York, which Toronto was called many years ago, to what it is today, whether it's the McPherson Estates, the Lonsdale Estates, whether it's the McDonald Estates that still have remnants here. So we've worked very hard with the developer, I must admit, and I'm happy because he's a neighbor of ours. I mean, we have good relationships, and I like to make sure that, you know, what he wants to do fulfills his agenda, but still respects our agenda. And I think we're very close here, and I think there's a couple of issues that need to be addressed, and we're reaching out to the committee to offer that opportunity.
Thank you very much. Questions, panel, for the speaker? Okay, I believe that takes us, we've been through the list now of registered speakers. Okay, we'll go back at this stage then to the agent, who will have a chance to respond to what has, pardon me, to the concerns raised by speakers in rebuttal. Let's go back to the agent.
Yes, thank you kindly, sir. Number one, the TLAB decision is binding. It is in effect. It is not buried or gone away. It is binding. It is in effect. The development of this land for 2 houses is subject to the conditions of approval incorporated within the TLAB decision. The TLAB decision requires that the site be constructed with a dwelling that's consistent with the site plan drawing that's on this screen right now, front elevation, the rear elevation, the side elevation, both side elevations. The lot coverage that affects is just over 30%. That is not an overdevelopment of the property. If you look at next door, Mr. Gagnoli's property is not substantially different than what is being proposed here. The buildings themselves and the houses and the construction of those houses is not in front of this panel. That is decided and it is in effect. The lot sizes fully comply with the zoning bylaw. The severance is the only thing that's in front of this panel, and that severance is identical to the severance that the TLAB approved, that Mr. Freed, who just told this panel that he wants this refused, that Mr. Freed signed an agreement, a commitment to accept and support this development. So if he is reneging on that support and signature, then he is reneging on a legally binding commitment. And I do not believe that that's appropriate, but I am also not a lawyer. The City of Toronto is also a signatory to that minutes of settlement and that agreement. So should this committee, should this panel not approve what the TLAB approved and that the City of Toronto signed as the minutes of settlement to authorize this revised proposal, because it's not the same one that was in front of the 2018 Committee of Adjustment panel that Mr. Ranoli and Mr. Englander wants you to believe to be the same one that the committee refused back in 2018. It's not. The City of Toronto signed settlement agreement that this severance is supported, accepted, and should be authorized by the TLAB. And the TLAB took that advice and the TLAB approved it. The fact that we are here today is only because the 1-year time frame to satisfy all of the conditions of approval and to get a certificate of official from the City of Toronto during the height of COVID could not be accommodated. So you heard from Mr. Englander that what is being provided here is exactly the same that is being already approved and signed by the applicant, William Granoli, Arnold Englander, Anthony Cohen, Trevor Eagleson, Stephen Freed, Joseph Jankovic, James Appleyard, and the City of Toronto. And I have all kinds of emails dating back to 2019 where everybody had those minutes of settlement.
Excuse
They
me,
all had
I've got to ask you right
signatures.
here. Yeah, this is all, I've got to ask you right now. Is that agreement, to my knowledge, that agreement is not part of your submission, though? Why would you not have submitted that with your application so that the committee could read it?
The Committee of Adjustment does not require a minutes of settlement that's entered into by private individuals, including the City of Toronto. The City of Toronto should have a copy of that agreement. But the TLAB decision itself makes reference to it. So the agreement is not something that is either in front of this panel or necessary for this panel in order to determine whether the Section 5124 criteria under the Planning Act are being satisfied. The Section 5124 criteria under the Planning Act have been satisfied, and that has been affirmed by the TLAB decision and the agreement that was made in order to accommodate this revision, this revised proposal that everybody has agreed to.
Thank you very much for that. Okay, panel members, questions for the applicant, if you have any. I'm not hearing any. So then, at this stage, I think we're ready now to take this application into committee for some discussion and moving toward a motion. Ms. Chan, please proceed.
I'd like to just start with a comment. Thank you for the applicant actually with his explanation that actually reflect what I think too, because what it is in front of us is only the surface. Any kind of variances regarding to the houses is already been approved by the TLAB, and we cannot overturn that. And what we are looking at only as a surface, and then he did give us a good reason why it's in front of us again is because of the deadline. They did not meet the deadline. And I think that makes it clear that what we are looking at is only the surface, and the reason why we is in front of us now. So I have no problem of approving it because this whole thing has been reviewed and approved by the TLAB, but it's gone through the process already.
Thank you. Other comment? Mr. Salomon.
I would agree with those comments, and I don't see what the purpose would be of deferring this application and what it would do relating to the severance.
Mr. Reed, go ahead.
I agree with my colleagues. I really see this more as a technical approval. It's been approved in the past, and that's the only thing before us as a committee is this an acceptable severance? And I think it definitely is based on lot patterns and previous approvals. So I'm happy to move a motion for approval subject to the development engineering condition.
Motion, is that seconding, Ms. Chan?
Yes, but you mentioned all the surface conditions, yeah, right? Yeah, the standard conditions, yeah.
Are there the conditions are there conditions, Mr. Reed or Ms. Chan, that you want to include?
The development engineering condition.
Okay. Okay, it is moved by Mr. Reed to approve, subject to development engineering. Is there a second to that motion? It is seconded by Ms. Chan. All those in favor, please, show of hands. That motion is unanimous. It is carried, and the application is so approved. Thank you. And that takes us to number 41. (130) Simpson Ave. On which application before us are the copy of minutes from the December 1, 2021 public hearing, copy of plan of survey, revised site plans, floor plans, elevations, cover letter agent, September, comment from urban forestry in the form of a staff report. There is interest or concern from 136 Simpson. Also from Tayyab Rashid, no address provided. There is opposition from 127 Simpson, 159, 139 Victor, 126 Simpson, 128, 132, and 156 Simpson. And there is a total of 15 form letters in opposition, signed by either owners or occupants of 100, 134, 135 Simpson, 49 Howland, and 135, 141, 150, 151, 153, 156, 157, 160, and 161 Victor Avenue. Also from 147 and 157 Simpson.
Through you, Mr. Chair, we also received a letter from the MPP of the Toronto Danforth area late yesterday, outlining to carefully consider both the letters of objection and letters of concern for this proposed development, overdevelopment of this site.
Thank you very much.
And we have that letter with us.
Thank you. Okay. Let us therefore begin by having the agent join us by stating his name.
Hello, can everybody hear me?
We do hear you.
Hi, my name is Christopher Smith. I am the agent for this file. I work for Woodsmith Construction at 80 Redwood Avenue, Toronto, Ontario.
Very good. Mr. Smith, you have 5 minutes to make your presentation on the application. Go ahead.
Okay, so we've done a fair bit of work since our last deferral. We have tried to sort of appease the opposition as much as we possibly could. I think the contention in this matter really revolves around just what defines a minor variance. And I think with this case, it is pretty obvious given the lot size that some of these variances look a lot worse than they actually are. So we are currently looking at a proposed third floor with a rear addition. If we want to pull up the site statistics that is on the next page below the site plan, I think we can get a good context of what we're talking about. So our entire proposed house is at 192 square meters, which is essentially, not a very large house. It's a sub 2100 square foot home. Our proposed third floor is at 54 square meters, which is, sub 600 square feet. So we are not talking about massive square footage that we are adding to this structure. The function of our SSI is a relationship to the lot area, which you can see at the top is 164 square meters. So essentially, we have a very tiny lot that we have a structure that we are trying to add a third floor in a responsible manner in order to give a single family home another set of bedrooms, because they literally have too many children for the number of bedrooms that they have. They've lived in the neighborhood for over 8 years. They love this neighborhood and, obviously want to develop this property as responsibly as possible. I submit that the revisions that we have made, I think, appeased some of the issues that were raised by, opposition, but unfortunately did not dismay opposition altogether. What we have done in regards to our sort of laneway suite is we have removed the second story of this suite. And now so if you return back to the site plan, you'll see that our single story laneway suite, which is an office designation for this particular application, occupying exactly the same square footage that a current garage stands in. If you would like, you could pull up my cover letter. I have a few pictures of sort of the area that I think would be very helpful towards the bottom of the page there. So as you can see, this is on the right-hand side is a visual from the back. You can see that this property is flanked by 2.5 three-story homes on all sides. It currently has a flat roof, which makes sort of any development and our sidewall height variance very necessary, because obviously any wall that we build that is up from a third floor is going to have that problem. You can see in the bottom of that picture that you have a current garage standing there. The peak of that garage is essentially at, you know, our height requirements for the flat roof of our laneway suite. So the disruption to the overall sort of community in this respect, I think for the development that we are asking for, is very reasonable in nature. And I think due to the level of opposition, I think I'll leave it at that, and then we can come back and we can ask any questions and talk from there. Thank you.
Thank you very much. Okay, with that panel, we'll go on to hear the speakers in opposition first and come back. Shall we do that? Okay, good. Okay, let's have the first speaker standing by. Join us, please, by stating your name.
Hi, Susan. You've been unmuted.
Good afternoon, everyone. I'm Susan Williamson. I am the owner at 126 Simpson, which is 2 doors to the west of 130. I've been an owner here since 2009 and have enjoyed a peaceful existence in this, historic Riverdale neighborhood of Toronto. My home is a heritage Victorian, as are many surrounding homes in the neighborhood, which was part of the reason to move here in the first place. I will speak to the collective neighborhood feedback, and that is that we are opposed to the changes and the proposal for, I think, 2 very clear reasons. Number one, despite what Woodsmith has said about consultation and lots of meetings and lots of agreement and lots of moving forward since we convened in September, we don't actually see any real changes made. They're very minor. There was no real consultation. There was no real discussion to come to a better place. So I think that's point number one. But more importantly, I think point number 2 is that the variances requested are not minor, despite what Woodsmith is saying. As per my letter submitted to the company, to the team, and on behalf of, I guess, close to 30 letters that our neighbors have submitted. I think what's important to understand is that what they're proposing, despite his negations about the fact that it's not significant, actually will have impact on our lives, on me at 126, and certainly on a number of our neighbors, as evidenced by our letters and our petitions. I think point number 1, this is precedent setting, and that's what's very frightening for our neighborhood and our community. As mentioned, we've got close to 30 opposing. We've had government support, both from municipal and provincial and federal levels. I think these variances are not minor whatsoever. There's not enough modification been done for our neighborhood and our community, and more importantly, not enough consideration for our respective lifestyles in this neighborhood and community that we love and cherish and respect. I think I've got a number of points to speak about that are not addressed and that are challenged by the current proposal. Number 1 being the character of our street and the fact that these designs still have not been modified to be in character with the Riverdale, the heritage community that is Riverdale in the city of Toronto. like Cabbagetown, like Rosedale, which is why the majority of the people that live here, moved here, bought here in the first place years ago. I don't think the design is considerate. It's not considerate to neighbors on multiple levels. I think the issue of spacing, as Woodsmith just said, the lot area is key. These are tiny properties that we're living on, and you know, growth has been upwards, admittedly, but I think there's severe potential massing issues, very serious shadowing issues. I just went outside before I joined the call at 4 o'clock this afternoon. Beautiful sunlight shining down, and I noted from my back garden that probably, I would say, at least 8 houses surrounding number 130 would be seriously impacted by the development of both their laneway house as well as, you know, the bump out to the back and the extension to the top. So we're talking about space, we're talking about privacy, we're talking about light, sunlight, shadowing, we're talking about massing and size of a structure on a very small, dense.
I shall ask for your final comment now, please.
My final comment is that I have a list of probably 15 more factors about how this will affect our both my personal enjoyment at 126 Simpson and on behalf of our more than 30 neighbors that have signed against this. We're willing to address and look at potential changes, but really our desire is to refuse as is. Thank you.
Your time is up. Thank you. Panel members, questions for the speaker? No. All right, thank you very much. Let's go on to the next speaker. Join us, please, by stating your name.
Yes, hi. Thank you, Mr. Chairman. My name is Carolyn Hay. I live at 139 Victor Avenue. I live with my family directly. Our house is directly across the lane north of 130 Simpson Avenue. And if it's all right with you, Mr. Chairman, I am here with my husband. We're going to take our 5 minutes together. We share one household, and he couldn't get into it.
Proceed.
Is that fine? Sure. Okay. So it's a bit surprising that Mr. Smith said that he tried to appease opposition as much as they possibly could. We had 2 Zoom meetings with the builder and the owners, which is a great start. We're more than willing to discuss this with them. But we thought it would be a bit more give and take. We thought it would be a continual conversation, but the builder on June 21st, 2022 said that they had decided to keep the main house design as shown in their previous revision. So that was it. It was a bit of a shutdown. Then there was no conversation beyond those 2 meetings. For such a huge build and such a huge change in our neighborhood, that doesn't seem like a lot of effort to appease the opposition, as he quoted, quoting him. Aside from the laneway house second story being reduced to 1 story, which still keeps quite a bit of increased height, by the way, because just because at that peak it's at that height, it means that it's quite a bit more looking over into our backyard. Besides that, those are just like small tweaks. And, you know, this is a lot of opposition. It's not just me. We're really upset about this. We're willing to come to the table, but it seems that that is what they want to end at. So what it leaves us with is still height variances, which it's still going to look into our backyard and the rear of our house, because it's still going to keep the full new third floor. It's going to keep still the non-complying bump out to the back of the house. And as I said, the laneway suite, which is still going to increase in height because it's going to have more mass there. So with all that, we're going to have our privacy super compromised, and our views and access to light and sun is going to be so impacted. And as Ms. Williamson said, yeah, we get tons of light coming back there above their house. We can see our view, we see clouds, we can see, you know, sky and horizon, and now we're gonna see nothing over there. It's gonna be massive shadowing, and it's just so big for such a small lot, crunched in beside neighbors, like right beside them, almost like parking a cruise ship in between two houses. So, you know, I'm all for change and evolution in neighborhoods, but within limits that the official plan of the city has sort of laid out for us to protect our neighborhoods. And this is not a minor variance. None of these are minor variances. So I'll just move over to my husband, who's going to take it from here, and that's it.
My name is Hugh Duffy, and obviously I live at 139 Victor. One of my specific concerns is with the creation of the laneway house. The laneway, I've been navigating that for 14 years. It's tricky at the best of times, let alone in the winter months when snow and ice make it extremely difficult to navigate. A laneway house is just going to make it create more density problems. And even if it's used as an office, it's proposed, you will have plumbing, etc., for a possible residential future laneway suite, and that could add security and privacy concerns. Just in general, the build seems to be mammoth compared to the rest of the properties on Simpson and Victor. Quite frankly, it's way out of character for this established neighborhood. I've lived in Riverdale for 25 years, and I've never seen this kind of overmassing, and I'm very concerned about it. Thank you.
Thank you. Questions, panel? No? Thank you very much. Let's move on to the next speaker.
Hi, Heather. You've been unmuted.
Good afternoon. My name is Heather Forrester. I am at 128 Simpson. So if you look on your screen, I'm the house directly, like it looks like south of this, but it's actually west. We've been living here for 16 years. So basically our backyards are joined, and we're very interested in any changes that impact not only our direct property, but also the surrounding neighborhood. And we hope we were clear in our objections in our letter, and we hope that you had a chance to review those, because the revised site plans by 130 Simpson truly only represent about a 0.6 meter, which is a 2-foot reduction in the main house depth, as the initial 2-story laneway suite proposal would not have gotten over the hurdle of an even greater variance test, which was 7.5 meters to the house. So removing that, I don't think would have even been approved. And so again, we're talking about they only tweaked a 0.6 meter off the depth. So, you know, when you look at the variance requests and whether or not they're minor, the first point I'd like to address is that the floor space index increased from 0.6 to 1.17, which is doubling the allowable density. This is a historic 2-story semi-detached house, and the houses in the neighborhood are 2 or 2.5. They're, on our block, there are no 3-story houses. They're 2 or 2.5. So adding a 3rd story really doesn't fit with the historic semi that they have right now. The lot itself is only, you know, 17.5 feet, which, you know, is very small to begin with. And so really increasing the house depth by 2.13 meters, and the outside walls will then increase by 1.7 meters. We're going to be blocked out from our window. So right along the back, if you can see the actual diagram, we have a transom window, which we will now be looking at a wall and a deck. So we'll be completely blocked out. We currently see trees. So it's very, very impactful for us. The second point is the garage, right? The structure being proposed to be torn down and rebuilt with a foundation, increasing its height by 0.7 meters, which is creating a large box structure that will impact our privacy and views, and in arguably one of the most confined laneways in Riverdale. So again, these structures touch our property. They will be looking down upon us. They will be looking back at us. So they impact our privacy from both inside and out. And, you know, blocking our sight lines to our trees, sky, and sunlight is very, very important to us. And that garage, as you can see, is only 4 meters. So if you look at the corner of that garage to our physical building, we're talking 4 meters, which is very, very small. So, you know, when you look at test 1, is it minor? I don't think doubling and the actual massing on that property is considered a minor variance. The second one, obviously, is the proposal desirable for the appropriate use of land and or building. It's really not sensitive into our street's character. Again, we're 2 to 2.5 stories, and you know, this is a Georgian, I believe, historic Georgian, that they're going to just stick a big box on top of it. And then you look at test 3, which is the general intent of the city zoning coding by and bylaw maintained. You know, Simpson Avenue is not, as stated in our letter, a townhouse neighborhood, and it really should be protected from such large and sudden increases in density that will alter really the fabric of our neighborhood. Like, bylaws are in place to control the actions of, in this case, property owners, to protect those around them, and the property owners directly impacted by this proposal feel that is far too much of an overreach. So 25 other neighbors and one neighbor submitting a letter of concern also have this view. It's not just us. So they have all submitted opposition letters, and Paula Fletcher also on the first round submitted a concern, and so did Peter recently. So we therefore respect the request of the committee to reject this application. So thank you for this opportunity to be heard.
Thank you very much. Questions, panel? Thank you. Okay, then let us move along to the next speaker. We'll ask that speaker to join us, please, by stating your name.
Hello, my name is Kimberly Peter, and I live with my husband, John Sauvé, at 132 Simpson, the house that is attached to 130 Simpson, and I'll be speaking on behalf of the two of us today. I'm not sure if it's possible, but before my time starts, is it possible to pull up my old letter from November 24th, 2021?
From November.
If it's not possible, then I'll attempt to speak without the images. I just thought that it would be reinforcing to see.
Give us a few, okay. So just before we start the clock, just stand by and we'll see if we can find your letter. That is the letter of Kimberly.
If it helps,
Kimberly Peter from November.
Correct, 5.96 megabytes, so it's not hard to find. And it starts with 2021-11-24.
We'll just take a moment.
Thank you.
Kimberly, if we can't find it, or if it's going to take too long to find it, then you obviously have a copy of the letter, so you can work from it to, we did find it. The staff
Wonderful.
here
Thank
are
you.
something else, so very good. We shall put it up.
Great.
There
okay.
you
And
go.
if you could, beautiful. Thank you so much. If you go to page 10 of this letter, if you can find page 10, I'm actually going to start with a couple of images that Chris Smith had borrowed from this letter on page 10. Yeah, just keep going there. Beautiful. I'm just going to start with those two if I could. Now, my peers here on the call have covered so much territory already, so I'm going to attempt to speak just from the impact of us as the conjoined neighbor. So first of all, I want to gratefully acknowledge the changes that were made, in particular the reduction of the two-story laneway to a single story. This and the minor two-story reduction, or 2-foot reduction rather, in the length of the second floor only part of the two-story addition, however, don't address the significant concerns that impact our home. So starting with this image, you can see that they're very similar. We bought this house 18 years ago in large part because of the Second Empire uniqueness of the property and its twin neighbor at 130. These images show a recent refronting. The second images show a recent refronting of the twin properties with the applicant at 130 Simpson. And if you scroll down to page 11, you'll see that the proposed rectangular box on top of one of these two unique mansard style roof properties will introduce a very significant anomaly on the street and to our shared historical presentation. Now, I realize one could argue subjectively that the mix of the modern and historic looks great, and in certain contexts it does, but objectively there's no precedent for this on the street for this particular juxtaposition. I'll also add that all third floor additions to date have been integrated gracefully into the sloped roof structures of these Victorians along the street. As the attached neighbor, this change would be heartbreaking and I believe an inappropriate addition. And if we look now to the backyard, I'll just cue this up. The other primary reason, and the second point I want to make, is that when we purchased this house in 2004, we really loved the richness of the natural environment, the canopy of 5 trees in the back, the views to the north, and the light for growing plants and spending time in our little slice of yard in South Riverdale. Now, although again, they made a 2-foot reduction in the length to the second floor of the back addition, the first floor will still bump out 2+ meters. That's over 6 feet. And the floor space index will still be 1.17. So if we scroll down to page 9, I just want to show you what we're going to lose. Scroll, yeah, okay, thank you. So the first image shows the view out the limited windows we have in the back. This is our kitchen window. We won't see any of that. That's gorgeous view right there. We won't see any of that. And then the second set of windows shows what it's like from our second store balcony. That will largely be obliterated. So these images, if you go down to maybe go up to page 8, just final point with this one. These images here attempt to show that being on the east side of the proposed development, the extended height and mass will effectively cut off much of the midday and afternoon sun to our rear yard. The smothering of light will reduce what we can grow in our side garden in pots. It'll reduce light to the trees and vegetation at the back of the property, and it will cast a large shadow during what is otherwise one of the most beautiful times of the day. As the attached neighbor, the increased density and the more than doubling of the floor space will mean loss of light views to our small treasured backyard space. This overdevelopment to a small and narrow semi-detached lot will serve only to make the experience of our home smaller and narrower, and we really don't believe it's minor. Thank you for hearing our concerns.
Thank you very much. Panel members, questions of the speaker? Okay. Mr. Moderator, that was the last speaker we had on this application? Okay. So now we will go back to the agent, who will have a chance to respond in rebuttal to the issues and concerns raised by the speakers.
Okay, hi everybody again. Thank you to everybody that has presented sort of their concerns with everything. I think I want to start with the massing, because I think there's a significant misconception as to what this massing of our proposal represents versus the images that are kind of being shown here. We currently are not seeking any building height variance whatsoever. We are under the 10 meter required. The third floor as presented is an 8-foot ceiling, very similar to the 2.5-story structures that are next to it. So this is not going to be massing over everything else. This is similar in height to the structures that currently exist and flank this building on both sides. I think from the character of the lot and just the overall neighborhood, this is a matter of opinion, and obviously there is no current heritage requirements whatsoever for this neighborhood. So we have tried to do as best as we can to come up with a proposal that marries both the historic and gives a modern interpretation. If you want to bring it up to the elevation view, the side elevation view, I think it's on the proposed. You can sort of keep going down. Keep going, those existing. I think you can get a sense of sort of what we're dealing with from the side profile. So as you can see from our front profile here, you can see that we have stepped back the building. So in order to respect the mansard face, the redoing of the entire front of the buildings, which, by the way, my company was the company that did all of that work, and we are very proud of it and want to respect it, we are looking to soften that transition. And again, with an 8-foot structure below the 10-meter height requirement, we are only getting a sidewall variance because of the fact that there is no roof that we can build this 3rd floor into. I think further to the comment that we did not spend enough time engaging, I think in the 2 meetings that were outlined, it was made very clear that the 2nd floor of that laneway suite was something that everybody was upset about. And it was sort of said by most of the people that now oppose still that they would support that laneway suite if that 2nd floor was removed. The reason that we did not go beyond removing, and the reason we cut back the 2nd floor, obviously the 2 feet, was to accommodate Kim's deck so that, you know, we were respectful to a certain degree in that respect. But we also have no building length variance being put forward today. So the reality of it is that the 3rd floor as it stands is pretty much, you know, again, a sub 600 square foot 3rd floor. Like, we need the space to do what we have to do. So I would submit that even though the impression is that this is a lot of massing, this is minimal massing, this is similar to the neighborhood. If we want to go back to my cover letter, I think we can pull up the picture of the rear again. I think that just says it all. So my cover letter. No, that's the old one, but I don't know if that's still the one that was from the recent. Yeah, so if you look at the backyard view, I think it's clear that you can see that all of these buildings, you know, are essentially 3-story structures at the back. You know, they're built into the roof at the front. That's why they have a 2.5-story designation. But everyone is aware that these are 3-story structures. We're proposing a 3-story structure. So obviously it is within keeping of the neighborhood. I think massing concerns for obviously a 1-story laneway house in the exact spot where there is currently a garage don't really seem to carry much weight. There is no effect to the laneway whatsoever because the garage and the laneway suite are in exactly the same location. So any access will be identically the same as before. Beyond that, I submit that you know, these are very reasonable requests and reasonable variances, and I submit that you guys approve this application as it stands. Thank you very much for your time.
Thank you. Panel members, are there questions for the applicant? Mr. Reed, go ahead.
Thanks, Chair. My only question is about the laneway suite in the back, and I understand in the previous iteration that 2 stories, I would consider that a laneway suite, but in its current form, it doesn't have what we usually see, which makes a laneway suite is actual habitable space as a self-contained unit. In terms of there's a small washroom, but there's no shower and there's no cooking facilities. So I mean, and maybe it's just semantics, I'm not sure, but do you see this as a laneway suite, or do you see it more as an ancillary building?
Thank you. Thank you for your question. Yes, I do see it as a laneway suite because one of the applications presented in the bylaws for laneway suites is an office use. And really, my client was looking after COVID for having a home office application. It was very difficult for him to get into the office, and he really liked the idea of being able to have office space that he could use. One other thing I would add, just in closing for other things, is there are also 12 letters of support for this proposal. There is not just opposition. That hadn't been mentioned at the beginning of the meeting. I forgot to mention.
At this point, you're just answering the questions.
Okay, my apologies. My apologies. Yeah, that's my answer.
Any other questions? No. Okay, then at this stage, we will take the application into committee for comments. Moving toward a motion, if anyone has comments. Mr. Salomon, please go ahead.
This is a very small lot, very narrow, about 17.5 feet wide. And I have concerns that there's just too much development that's being proposed, and that the proposed third floor has sidewall heights that are very high. And given the narrowness of the lot, the impacts then of that height of the sidewalls is significant to the adjacent landowners. And I think then that the FSI and the sidewall heights are just create an overdevelopment for this small lot.
Thank you. Anyone else? Mr. Reed, go ahead.
Thanks, Chair. I have a different perspective. I agree that I understand that a lot of the neighborhood has a lot of concerns with this, but I see it more as an evolution of a relatively static neighborhood. There are many 2.5-story houses, and I think the applicant was correct in saying towards the rear of many houses, they basically become 3-story houses. I think there has been efforts made to lessen the impact of what's being proposed. I think the laneway suite going down to 1 story is a very big move. And I think the step back on the 3rd floor, both from the front and rear, make a change. And I understand that people don't like that aesthetic from the street, that it breaks up the aesthetic, but I do think it fits within the physical structure of the neighborhood, not the aesthetic structure, but the physical structure. And I think that's important to differentiate. Also looking at the variances themselves, stepping away from the more perhaps emotional or aesthetic issues, I think the variances themselves are really quite small. So I'm going to be supporting this application.
Ms. Chan. Go ahead.
Excuse me, I can't saying something.
Ms. Chan, yes, go ahead, please.
Okay, yeah, I want to add my comment, and I do agree with the neighbors' concerns about I think mainly because of the aesthetics, but I think that this application has been gone through a lot of discussions. From the last time I remember it was from 6 variances, now reduced to 3. I think the applicant actually have made an effort to minimize the impact. And I remember also the laneway house before was like 2-story, and I actually agree with Peter that I accept this as like a step forward or like a transitional addition or build form, and I have no problem with this application, and I will be supporting it.
Okay, for my part on this one, I am very sensitive to the neighbor on the other half of the semi, because it does have impact because of the narrow lots. I think it could have been more sensitive, but it is the fact that they have reduced the laneway suite, for example, and some of these other things shows some sensitivity, but I would have liked to have seen it gone, that sensitivity extended in a perfect world. However, as I look at the actual variances that we are faced with, and in the context of what I've heard, I am able to support the application. So I'll look to someone, please, to make a motion. Mr. Reed.
Thanks, Chair. I'm happy to bring a motion for approval of the application subject to urban forestry conditions.
That is seconded by Ms. Chan. So moved and seconded to approve. All those in favor, please show of hands. Those opposed. And let the record show that Mr. Salomon is in dissent on this application. The motion is carried. The application is so approved. That takes us to number 42. 173 Chaplin Crescent. We'll ask the agent to join us, please, by stating your name.
Good afternoon, Mr. Chair, members. Heidi Evangelista, 53 Bentworth Avenue, Toronto, M6A1 Peter 5. And I'm here on behalf of the owner of 173 Chaplin Crescent.
Good afternoon to
Do you need a...
We'll see
Good
if we need a
afternoon.
presentation. I know there's been quite a bit of revision since the March deferral. Panel members, anyone requesting a presentation or questions? Not hearing any questions. Okay, Mr. Reid, go ahead.
Maybe, yeah, just maybe a brief description about the changes since the last application would be helpful.
That would. Yes, that's a good idea.
Yes, absolutely. Through you, Mr. Chair, Member Reid. So what we've done is we've made several revisions. Now, this is an addition alteration to the existing home. So there are some things like such as setbacks that, unfortunately cannot be changed. We have met with the neighbors adjacent to the property, and what we've done is we have decreased, we removed the length variance completely. One of the other issues that, and concerns, I should say, concerns that the neighbors had was the runoff of the water, because we do have the eaves that go at the sides. So the runoff the eaves trough, we've now put one on the side that will face the front of the house, and then the one at the back of the house. So we did change that. We pushed the house back a little bit, so we removed the front yard setback. We've increased the soft landscaping. We removed the overall height. We now comply with the overall height. We do have main wall height that does remain. However, because of the shape of the roof, we have on the left, we have a 6.39 main wall height, and on the right, we have the 8.76. And at the rear, we also have the main wall height. We brought it down, but it's taken to the very peak. So at the back, there's a peak at the back of the house, and that's where that main wall height has been taken. So we also changed the chimney breast, so it would come in a little bit, it wouldn't protrude as much. And we have also altered the stairs, because what we've done is the stairs and the front porch we've incorporated into the wall of the home. And so we've altered that. We pushed it back a little bit more. The parking space, we have decreased it a little bit just so that we can have more of a front yard landscaping. So we have altered quite a bit to the home, considering we are working with the existing footprint.
Further questions? Mr. Salomon, please go ahead.
The proposed side yard of 0.2 meters.
Yes.
Does that apply to the rear addition, or is it really just to a small portion of the existing house?
Through you, Mr. Chair, Member Solomon, that applies to the existing portion of the house. There's a chimney breast there. You'll see it right there, closer to the front, and that's where it. You'll see where it pops out. And that's existing, and that will remain.
Thank you. Very good. I'm not hearing any more questions, so we can at this stage take this application into committee. For a motion, please, unless there are comments first. Mr. Reid, please.
I'm happy to bring a motion. I think that this is an acceptable application and is in line with recent rebuilds in the area. I think that there have been meaningful changes since the last go round. And I think what's being proposed is not, the variances are not necessarily negatively impactful on the neighborhood or on the broader neighborhood structure. So I move approval with no conditions.
I think forestry applies. Anybody else see that? Is there forestry on this? No?
No.
I didn't see it, but.
In that case.
I'm wondering if we can, I'd be happy to support the motion. I'm wondering if we can add a condition to tie it to the site plan. Especially in relation to the side yard, because the side yard of 0.2 meters really only applies to just a small part of the house.
That's a very good point, Nimrod. Thanks. Yeah, I'd be happy to include that as a condition.
And forestry does not pertain, so. Okay. There's the motion. Is there a second to that revised motion? It is seconded, Mr. Solomon. Okay. Moved and seconded to approve. Those in favor, please show hands. And that's a unanimous vote to carry the motion. That application is approved. On the final application on today's agenda, 8 Britton Street, the following materials are before the panel. Copy of minutes from the August 10th public hearing. Copy of submitted materials. Correspondence between the agent and the zoning examiner, received September 7th. Copy of correspondence between the agent and the supervisor of right-of-way management transportation, August. There is emailed correspondence from the supervisor of transportation, 14 September, and there is support correspondence from 183 Queen East and 177 Chaplin. And we'll ask the agent to join us, please, by stating your name.
Good afternoon, Mr. Chairman, members of the committee. Can you hear me?
We do hear you. State your name, please. Yes.
Oh, thank you very much. My name is Paul Cronus. I am a land use planner in the office of Weir Folds in Toronto. And I am, as you stated, the agent for this application. I'm prepared to go however way you wish me to proceed. I have a presentation, or I can answer your questions. I can advise you that some of the variances before you, variance 1 and 2, I can give you an update on those if you like. Maybe it would help. Yes.
Yes, I think if we need an update on that, please go ahead.
Okay, thank you, Mr. Chairman. This matter was deferred from your August 10th meeting by notice deficiency. You'll note from the email exchange with the transportation people, the question I was asked was there were 2 assigned parking spots on the city boulevard, and I was asked where are they, and because there's 0 parking on the property, it's landlocked in terms of it's built to its limits to the laneway and to George Street and to Britton Street, then the notice was incorrect. It should have said 0 parking provided on site, and I agreed. So we went back and we revised the notice, and it is before you today that shows variance number 2 says 0 parking spaces on site. And I will update you very quickly on that because a significant event took place today. In respect to variance number 1, I can delete that. City of Toronto passed a bylaw to correct the deficiency, so variance number 1 is not required anymore, and I think the email correspondence states that. In respect of the parking, sir, today the City of Toronto and the sole appellant on the new City of Toronto's zoning bylaw that reduces, that has no minimum parking requirements, they have settled and presented a zoning, they presented an order to the Ontario Land Tribunal that will put the bylaw into full force and effect. Of course, it takes a little bit of time for the decision and the order to issue. So variance number 2 will effectively be dropped as well, no longer required. And it's just a matter of when the decision comes out. But I can't drop it today because the order hasn't issued.
Exactly. So but I think you're saying that you wish to drop number 1 today?
Correct, sir.
Pardon
And
me?
number two, the update is that also.
I understand the update, but I don't, we can't, we have to deal with things as they stand,
Yes,
as
sir.
you say.
Thank you.
Two should stand,
Yes,
I think, but one, you're saying you'd like to drop 1.
correct, sir.
You don't
It's
need
no
1 any
required.
longer.
Yes. The City of Toronto passed a zoning bylaw that corrected a technical deficiency in the bylaw. If you like some background, if there's a parking spot required, then there's a default of 1 accessory parking space that's required, and that's why the variance is there. But that was a defect, and they corrected it through an enactment of the zoning bylaw at the end of July. So with confirmation from the zoning examiner, a new zoning that issued number 1 is no longer required, so I'm prepared to drop that.
Okay,
And I can
excuse
give
me,
you
okay.
Yes, sorry.
That's fine. So, I just want to check with the Deputy Secretary Treasurer. Does that make sense to you, to drop number 1?
Through you, Mr. Chair, the applicant is requesting that,
Yeah, okay.
right? I mean, it
Very good.
doesn't hurt to keep it in.
Yep, so.
Just so there's no issues at the time of permit, but if the applicant wishes to remove, then he's taking that responsibility.
Okay. So applicant, one last time to ask you, do you wish to drop your first variance?
Yes, sir. And if I could just give you a little background. I used to chair the Committee of Adjustment in Oakville, so I know these questions are very important. And I don't like seeking variances when variances are not required. It's just a jurisdictional question that I have personally. So I want to drop number 1 for that reason, and I respect the Deputy Secretaries are saying keep it there in case you need it, but I do not need it.
Okay.
And I don't like you to grant the variance when it's not
Thank
required.
you. We have it now. Okay.
Yeah.
So we are revising the application to drop minor variance number 1. That's all.
Thank you.
All right. Panel members, any questions for the applicant? If not, we'll take this application into committee for a motion. It's a revised application now. Mr. Reid, go ahead, please.
I'm happy to bring a motion. I think these are really almost technical variances that are being sought, and I see no negative impact coming from these variances, and this is a good reuse of an existing building. So I move approval of the application as amended with no conditions.
Is there a second to that motion? Mr. Solomon seconds. It is therefore moved and seconded to approve the revised application. All those in favor, please, show of hands. Unanimous vote. Motion carried. And the application is so approved. And with that, the day's agenda is completed actually at 6:40 p.m. And I want to say to panel members, thank you for maintaining focus on what was the work at hand, and we got the job done. Ms. Chan, go ahead. You have something to say.
I say thank you. Good night. No? Yeah.
Nimrod and Peter, thank you very much. Very good.
Thanks, and thanks, staff.
Thank you, everyone. Have a good evening.
To staff, I also say thank you for your support and your preparation. It's always flawless. Thank you.